Ms. Rivers, are you able to hear us?
Yes, I am. Good
Great.
afternoon.
Good afternoon. We'll get started. All right. Thank you for shifting to 2:30. I know I'm a little after 2:30, but that was when I was able to wrap up other court work today. We're here at a minimum on 25 SC 002906, State versus Kayla Brown. Ms. Brown is here with her lawyer, Mr. Ford. Mr. Wooten is here for the state. Mr. Wooten, are we handling only Ms. Brown's plea today and not Mr. Jones and Ms. Jones?
I believe that's right, Judge.
Okay, got it. All three defendants are on the upcoming trial calendar, so I guess if we don't resolve it today, we can handle it through trial. Mr. Ford, is there anything we need to address before we start the plea colloquy?
No, Your Honor, just as a matter of housekeeping, I would prefer respectfully, good afternoon, Your Honor.
Good afternoon.
To have my client on the witness stand after the colloquy. And I would engage in any discussion with her, questions relative to things. And it is my understanding, just for your edification, that subsequent to my client's plea today, that both of her family members aforementioned would be pleading whenever the court would allow. I think they were, for lack of better terms, wanting to see how today went.
Okay.
But I will tell you, is my understanding, and I know that one of the aforementioned is in court, although I've not spoken to her because she's represented by counsel. It's my understanding for my client that both of her family members are intending to plead guilty and intending to be jointly and severally liable for the outstanding restitution,
Okay.
but just not today.
They'll do what they think is in their best interest as counseled by their attorneys. Today we'll focus on Ms. Brown, and we will get through the state's portion of the plea colloquy and maybe some of mine in the standard setup. Because Ms. Rivers is virtual, you all are welcome to stay at counsel table if that's easier. You can use the podium. Someone can be at the witness stand at the appropriate time. I'm not a stickler for where people are, as long as you are audible to Ms. Rivers, and she can hear you if you're near a microphone. So I'm good with however you want that to work. Mr. Wooten, anything we need to cover procedurally? Do you have any insight as to what's going on in the other two cases based on this?
Not in the other two cases yet, Judge, but I guess my only question is, because this is non-negotiated and we have multiple victims who want to make impact statements, just what order do you want things in?
So I will want you to get through the colloquy, and then we'll see if there's a factual basis, et cetera. It will then be time to hear from victims who want to be heard before I pivot to Mr. Ford for anything he wants to present, and then obviously if Ms. Brown wants to say anything. Victims have a right to be heard. I will certainly hear from them, as I have many times and will continue to do. Ms. Brown has a right to be heard, but the typical flow, I don't see any reason to pivot from it other than there are a whole bunch of victims, but I'll hear from each of them if they think they're adding something to the cumulative impact. Is that it would be you, then the victims, then Mr. Ford and Ms. Brown, or whatever, however he chooses to orchestrate that side.
And then do you want my recommendation prior to the victims, or does it matter?
Prior to Mr. Ford starting, I want to know what you're recommending, whether that's before, in between, or after the victims. Just before you say, that's it from the state, I'll need to know, well, what is it that you think I ought to do?
Sure.
However you want to weave that in. And I didn't mean to skip over, I have Ms. Harvey from pretrial, so she'll be providing criminal history information, if there is any. I'll get that before the victim so that she can then be on her way and doesn't need to be here for the rest of the proceeding. But that is my proposal. So let me get you all. We've got that camera and Is that screen on?
It is.
It is not on, if you look at
At
it?
one point, but
Okay, let me see if I can get it. Don't break anything. I may be able to make it work. Nope. So you will be. All right, you'll just be a little smaller.
sure.
There have been issues with these machines all day, but at least we're connected right now. So we'll count that as a victory. Let me say this to you, Ms. Brown, before we get rolling. In a moment, Mr. Wooten is going to put you under oath. And once you're under oath, you'll need to answer all his questions truthfully and completely. If at any point during the conversation, and we'll all be talking, not at the same time, but I'll have some questions. Mr. Wooten will have a lot. Mr. Ford will have some things to say. If at any point you have questions, someone says something you don't understand, or you've got a question about something, it's important you let Mr. Ford or me know. I need to make a finding at the end that you've understood everything that went on. And one way I know that is if you pipe up, if someone says something, not that you disagree with, that's different. I don't want you interrupting because of that. You'll have an opportunity to share your view on things. But if someone, I don't mean the victims in this case, but if Mr. Wooten or I say something, like, that's not what Mr. Ford was talking about, or I'm confused, will you let your lawyer or me know?
Yes, sir.
Okay, great. You can take a seat. When you're ready.
Sure. All right, Ms. Brown, could you raise your right hand for me, please? Do you solemnly swear or affirm that the testimony that you are about to give in this matter now pending before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And could you please state your true, correct, and legal name?
Kayla Brown.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
My antidepressants and my anxiety medication.
Okay. And is your antidepressants and anxiety medication, does taking that today have any effect that would make you not understand what's going on in court today?
No, sir.
When do you take the medication each day?
In the morning.
Did you take it this morning?
Yes, sir.
Okay.
And Ms. Brown, how old are you and how far did you go in school?
I'm 27 and I'm in college for my Bachelor of Science in Nursing.
Okay. Are you able to read, write, and understand the English language?
Yes, sir.
And do you understand that you are charged with the following offenses in the indictment? In count 1, violation of the Georgia RICO Act, counts 2 through 14, theft by taking, counts 15 through 27, securities fraud, counts 28 through 33, insurance fraud, and counts 34 and 35, identity fraud. You understand that that's what you're charged with?
Yes, sir.
And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or if you remain silent, you would have a jury trial.
Yes, sir.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, sir.
Do you need any more time to discuss the case with your lawyer?
No, sir.
And are you satisfied with his services?
Yes, sir.
And Mr. Ford, are you satisfied that your client has a full understanding of the proceedings? And Ms. Brown, have you reviewed the indictment in this case with your attorney?
Yes, sir.
And counsel, does your client waive formal reading of the indictment?
We do.
Do you waive any and all defects in the indictment for purposes of this plea?
We do, sir.
And Ms. Brown, you've been arrested on these charges previously, is that correct?
Yes, sir.
And Judge, the state's unaware of any outstanding warrants on these charges. Ms. Brown or your counsel, are you aware of any other outstanding warrants on this case?
We are not.
And Ms. Brown, do you understand that you are entering a guilty plea to the following offenses and that these are the minimum and maximum sentences for those offenses as provided by law? And I'm just going to walk through each one with the minimum and maximum. And count 1, violation of the Georgia RICO Act, minimum of 5 up to 20 years. Counts 2 and 3, theft by taking, minimum of 2 up to 20 years. Count 4, theft by taking, minimum of 1 up to 10 years. Count 5, theft by taking, minimum of 2 up to 20 years. Count 6 through 8, theft by taking, minimum of 1 up to 10 years. Count 9, theft by taking, minimum of 1 up to 5 years. Counts 10 through 12, theft by taking, minimum of 1 up to 10 years. Counts 13, theft by taking, minimum of 2 up to 20 years. Count 14, theft by taking, minimum of 1 up to 10 years. Counts 15 through 27, securities fraud, minimum of 1 up to 5 years. Counts 28 through 33, insurance fraud, minimum of 2 up to 10 years. And counts 34 and 35, identity fraud, minimum of 1 up to 10 years. Do you understand that that's the sentence ranges by law for each of those counts?
Yes, sir.
Okay. And do you understand that this is a non-negotiated or a blind plea and that the state will make a sentencing recommendation to the court?
Yes, sir.
Do you understand that your attorney will also make a recommendation to the court and that you'll have the opportunity to present any evidence in mitigation?
Yes, sir.
Do you understand that the court, because it's a non-negotiated plea, can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge, with one exception that we are putting a cap of 7 years on the prison time? Do you understand that the court can sentence you, other than that cap, to anything else?
Yes, sir.
So walk me through how a cap applies to me. Because we're past final plea. I don't know, I'm not saying this to spook anyone, but I've not ever encountered a plea structured that way.
Sure.
You're going to recommend what you recommend. In looking at these numbers, assuming there's not merger or anything, the ceiling is 100 and something years. Isn't that really the cap?
I guess, Judge, the way that I've approached it in the past on other cases is just that her voluntariness to enter the plea is conditioned on the court accepting the cap.
So if I were to say, having heard all this, including the impact on the victims, I think it's a 10-year to serve case. There wouldn't be a deal because I'm not part of the deal. So that I don't want anyone to be surprised.
Sure.
Not because I'm already made up my mind. I don't know how this is going to, maybe it's probation, maybe it's 10 years to serve. The cap isn't, you're not asking for more than 7. It's somehow I couldn't give more than 7.
I guess the way I've structured it in the past under these circumstances is just that if the court were to sentence higher than 7, I guess the defendant could
Withdraw.
Withdraw.
Okay. So you sort of created in your mind, and it may be how it works out, a new final plea, because if I were to say, you know what, 10 years is the right answer here, 10 years to serve, that would still be the right answer, but it would allow Ms. Brown to say, I'm going to go to trial instead. Given those stakes, I'm going to see what happens at trial.
If the court, of course, the court would have to accept those terms, but
Okay. All right. You can keep going.
sure. And Ms. Brown, do you understand that you would have until the end of the term of court to file a motion to withdraw your guilty plea?
Yes, sir.
Do you understand that if you chose to file a motion to withdraw your plea, that the discretion to grant that would lie within the discretion of the court?
Yes, sir.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
And do you understand that this is a guilty plea which will be permanently recorded on your criminal history?
Yes, sir.
Do you understand that if you were charged with a crime in the future, that this plea could be used to enhance sentencing, including on a federal case?
Yes, sir.
And do you understand, well, are you currently on probation or parole?
No, sir.
And are you a United States citizen?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea, just as there would be from a conviction following a trial? For example, your guilty plea might affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, sir.
Do you understand that by pleading guilty to a felony offense, you cannot receive, possess, transport, use, or own a firearm, and that if you did, you could be charged with another felony offense, even if you were pleading under the First Offender Act?
Yes, sir.
And are you going to ask the court to treat you as a first offender in this case?
We are, counsel.
And Ms. Brown, have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, sir.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No, sir.
And has your lawyer explained to you how the First Offender Act works?
Yes, sir.
Do you understand that if you violate the term, if the court places you on first offender probation or under a first offender sentence, that if you violate the terms of that sentence or if you commit a new offense, that your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum for each charge in the indictment.
Yes, sir.
Do you understand that by entering this plea today that you're waiving any and all defenses, including any mental health defenses, by entering this plea today?
Yes, sir.
And do you understand that by pleading guilty, you are giving up the following rights, and I'm going to read them out to you one at a time to make sure that you understand. The right to trial by jury,
Yes, sir.
the right to remain silent and not incriminate yourself,
Yes, sir.
the right to see and hear the witnesses against you and to question them,
Yes, sir.
the right to have the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney,
Yes, sir.
the right to the presumption of innocence, which means that the state would have to prove that you're guilty of each charge beyond a reasonable doubt,
Yes, sir.
the right to testify on your own behalf or remain silent, and the jury would be told that they cannot use that choice against you,
Yes, sir.
the right to present other evidence of your own and call your own witnesses in your defense if you choose to,
Yes, sir.
and the right to appeal if convicted of these charges after a trial.
Yes, sir.
And counsel, are you satisfied that your client understands that these rights that they'll be waiving by entering a guilty plea to these charges?
I am.
Ms. Brown, has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea today?
No, sir.
Is it your decision to waive these rights that we just talked about and enter a guilty plea because you are in fact guilty?
Yes, sir.
And as to indictment number 25 SC 002906, how do you plead to count 1 violation of the Georgia RICO Act?
Guilty.
How do you plead to counts 2 through 14 theft by taking?
Guilty.
How do you plead to counts 15 through 27 securities fraud?
Guilty.
Counts 28 through 33 insurance fraud?
Guilty.
And counts 34 and 35 identity fraud?
Guilty.
And is this guilty plea freely and voluntarily given with full knowledge of all of the charges against you?
Yes, sir.
Do you understand that you do not have a right to appeal directly from your guilty plea, but if you believe that there was some error in the plea, that you could apply to the appropriate appellate court to request a discretionary appeal?
Yes, sir.
And do you understand that the discretionary appeal procedure, which is outlined in OCGA 5-6-35, must be completed within 30 days of today?
Yes, sir.
And further, do you understand that you only have 4 years from today, because these are all felony charges, to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
Okay. Your Honor, as to a factual basis, if this case were to proceed to trial, the state submits that the proof would show that on and between February 24th, 2019 and November 25th, 2022, the defendant, Kayla Brown, along with Adrian Jones and Trakella Jones, conspired and endeavored to acquire and maintain an interest in and control of United States currency through a pattern of racketeering activity in Fulton County, Georgia, and elsewhere. The primary objective of the racketeering scheme was to steal money from numerous unwitting victims through the operation of a sham securities brokerage firm. The defendants falsely represented that Brown was a licensed stockbroker and an agent of Global Investments LLC, which was a fictitious entity. The defendants received large sums of money from victims under the false pretense that the funds would be used to purchase stocks and other securities on the victim's behalf and for their benefit. To further the scheme, Brown created and assumed false identities and communicated with victims using fraudulent email accounts to create the impression that Global Investments LLC was a legitimate business with multiple employees. Specifically, Brown created the false identities Gail Octum, GAILOCTUM, and Kathy Bertum, KATHYBERTUM, to send emails to multiple victims. Brown would tell victims to contact Octum or Bertum for more information on how to withdraw funds or make other transactions in order to create confusion, delay victims' withdrawal requests, and deflect responsibility away from Brown by making it appear that any inability to access funds was because of other employees. The defendants also used social media platforms to post false and misleading depictions of wealth to lure victims in with the promise of financial success. The victims lost varying amounts of money, some as little as $940, others as much as $122,000. The defendants would instruct victims to deliver funds to them via various methods, including cash, checks, wire transfers, Apple Pay, Cash App, PayPal, and Zelle. In some cases, Brown received the funds directly. In others, Brown would instruct victims to make payments to Adrian Jones or Trakella Jones, and the funds would then be routed to Brown with Adrian Jones or Trikella Jones receiving a portion of the funds. The defendants also solicited and received payments from victims for fictitious stock insurance policies that were purportedly designed to protect investments from market volatility in the wake of the 2020 presidential election. To maintain the illusion of legitimacy, the defendants provided victims with false documents, including fake stock certificates and insurance policy documents. Those false insurance documents were provided to victims Tony Burbridge, Kathy Butler, Richard Butler, Keontae Colton, Deanna Palmer, and Kaylin Usher. Instead of using the victims' funds for legitimate investment purposes, the defendants instead used the funds for their own personal benefit, including for travel, luxury goods, and cosmetic procedures. The total loss to the 25 named victims included, and Judge, do you want me to give the individual victim breakdown, or do you just want the total?
Do you have a nice little handout that lists loss by victim?
I can, it's in the Loeffler-Fry notice, and so I can provide that.
I've got that.
Perfect.
That's helpful. That way you don't need to read it in the record. It's
Sure.
in the record.
Sure.
And that is, let me find it again.
And there was an amended one that was filed that's got the most up-to-date numbers.
There's one from January 15th.
I think there's a subsequent.
Oh,
one.
yes, amended, February 3rd, docket 26. I will
Yes.
open that up. Okay,
Yes.
great.
And the total loss was at least $611,115.58. All of these offenses occurred in Fulton County, Georgia. And Judge, if you'd like, I can go ahead and put the state's recommendation on the record.
Yeah, why don't you do that? Then I have a few questions for you.
Sure.
I'll hear from pretrial services, and then we can start hearing from those victims who want to be heard.
Sure. And I'll try to make this as simple as I can, but as to count one.
Why don't you just give me the overall sentence? I can figure out how to break it out unless there are some mandatory this or that type counts. I see from the Loeffler-Fry notice, it's 15 to serve 7.
Yes.
With count 1 being the 15 to serve 7, and then everything else is 5 years to serve concurrent.
Yes, that's exactly right, Judge. So effective sentence of 15 years to serve 7, balance probated with the cap of 7 on serve time that we previously discussed, if the court would accept that. Special conditions. And again, this is all, it's exactly what's in the Loeffler-Fry notice. So
Yeah, so I think what I'm going to do is make, one, it's in the docket, but I will make sure that this, if you will email the February Loeffler-Fry notice to
Yes.
Ms. Nelson and or Ms. Rivers, either one, Ms. Rivers, court reporter, Ms. Nelson, litigation manager, we'll make it an addendum to the transcript. So it's in the record that way. That way you don't need to read it. And insofar as I adopt them, if I have a probated part to the sentence, I'll just be able to work with Ms. Nelson saying, take these bullet points right here. And then Mr. Ford may have additional ones or may want to amend them, but you've got it that way.
Sure, I'll do that. I'll send it to Mr. Ford as well, just so that everyone's got it fresh. And that is all I have on behalf of the state, other than any questions from the court and our victim impact statements.
Okay. You described, I've already forgotten the name, Global Investments? What was-
Global Investments LLC.
Yeah, as a fake LLC. Was it in fact a real LLC, but it was a shell? It wasn't
Yes.
a stock brokerage?
That's correct, Judge.
Okay, so there was at some point in time with the Secretary of State, Global Investments LLC.
Yes.
It may well have been registered to Ms. Brown or to Ms. Octum, but it was a shell.
Yes, that's
Okay.
correct.
You have very specific start and stop dates to the case. February 24th, 2019, and then effectively Thanksgiving of 2022. What's the significance of those two? How did this end? How did it start?
Those are based on the evidence that we have. The very first victim sending any sort of funds was on that February 24th, 2019.
Yep.
And then the very last documented sending of funds was the November 25th.
Okay, so there may well have been misdirection and misinformation after November 25th as people are saying, where's my money?
Sure.
But the last time someone actually voluntarily parted with their resources thinking, great, I'm buying stock insurance or I'm investing in whatever Global Investments was peddling, would have been at November 25th.
Yes.
Okay. Mr. Ford is seeking first offender on behalf of his client. Do you have a perspective on that?
Judge, we are opposing first offender.
Okay. All right. I would like very much now to hear from Ms. Harvey, if you have any criminal history information on Ms. Brown.
Yes, Your Honor. Good afternoon.
Good
3
afternoon.
cycles, no prior felony convictions. The last arrest was December 16, 2021 for theft by taking, and that case was dismissed. Nothing further.
Thank you so much, and thank you for being here. You are free to go.
Okay, you're welcome. Thank you.
Mr. Wooten, tell me how you would like to work through. Let me say this first to everyone who's on the call, who is a victim or associated with a victim in this case. I'm happy to hear from each of you. You've got a right to be heard. Some of you have spoken to me many times before. You don't need to repeat what you said before. I have felt your pain and your frustration and your anger, and you can pick the other nouns and adjectives. But I am happy to hear from you now. If there are several of you from, I'm gonna call it the same victim complex, it's the same household or whatnot, if you want to consolidate into having one person speak, that's okay too. And you don't have to speak at all. Your election not to speak doesn't mean you didn't lose money, that you weren't swindled, and that this doesn't matter to you. Most of all, you have a right to be participating in these proceedings, to see and hear what's going on. But with that said, I am here to listen. I may have questions, but mostly to listen. Mr. Wooten, how do you want to cycle through everyone so
Judge, my
that
thought was the lawful Friday notice lists out all the victims. My thought was just to go in that order.
Okay.
Call for a victim, call for each victim if they want to make a statement, they can. And then we've also got, I believe, 2 written statements that would need to be read into the record.
Okay, and do you want to do those at the end?
Sure.
Okay, help me remember that they're there, because I'll think, oh, we're done. We've heard from everyone who's on the Zoom. Okay, I'm going to have my Fry notice up as well so I can follow along. Okay.
So I
I
believe.
mean, I guess I can do that because
Sure.
it's right there. Is Ms. Palmer on? She is. Ms. Palmer, is there anything you want to share? And I should add one last thing. I promise I'll stop interrupting. If you do want to be heard, you need to be seen as well. So you will need to turn your camera on and then unmute. Please, only one person unmuted at a time. And then introduce yourself and spell your name for the court reporter. And then I'm happy to hear from you. So only in order of the document that I've got, Ms. Palmer, you're up first if there are things you want to say.
My name is Deanna Palmer. The spelling of my name is D-O-N-N-A. Last name Palmer, P-A-L-M-E-R. I just want to say that this day and time is long awaited. I can't express anymore how devastated and how hurt I am to the point where I am now on anxiety medication. I am now on antidepressant because of Miss Brown's actions. It was calculated, it was cold, it was callous, and she knew exactly what she was doing. I do not agree with the first offender because she's done this too many times and to several persons. She knew exactly what she was doing. I am now still suffering from the ramifications of her deceit. It's almost like a murderer. Like, she's continued to do this. She knew exactly what she was doing. She took our money purposefully to scam us, and she did exactly that. I am now still suffering from that. I am suffering from that loss. My child is suffering from that loss. I don't have any remorse for her or her kids or her being a mother or her being in college or any of those things, because she deceitfully, purposefully deceived us. And she did this to several people, and she should not be granted any leniency. I want her prosecuted to the fullest extent of the law, because I'm still dealing with it. She did not care about my family, my son, the things that I had going on. She wanted to deceive me, and she did, and I want all of my money back. Every last dime. I want restitution. I want to sue her. I want her to go to jail. I want the 15 years and not the 7, because that's what she deserves. If it's going to be justice for anyone, it should be to the people that she impacted, the people that she deceived and that she hurt, and the people she lied to with this elaborate scheme that her and her family came up with to victimize us.
Ms. Palmer,
Thank you.
you're welcome. And I appreciate you sharing that. What was your connection to Ms. Brown?
I watched Miss Brown grow up. She was a family. My family and her family are very close.
Okay.
I've been knowing Kayla since she was 12 years old. I mean, she's invited me to birthday parties for her children. So I can't see how she could callously and heartlessly take money from me when I would have given it to her freely.
Okay.
But
And
under
Ms.
the false pretense of, and the documents that she provided and the emails and the conversations with those two individuals that I felt like was her. Even when I told her that my lawyer said that that was fraudulent, that this was a scam. Oh, she denied. Like I have all the text messages and all the emails. I just can't see how she would do this to me. She's known me most of her life. And it was cold-hearted and calculated, and I want her prosecuted to the fullest extent. No leniency, Judge. None.
What made you think, if you knew her so well, what made you think she was a stockbroker?
Because of the flashiness, the things she would say she was done for others, her grandfather, like she was very detailed in the people that she's helped before. Mm-hmm. And the other people that have cashed in their stocks and how she was doing it. And, even having the LLC and then providing me with the receipts for the stock insurance and then the people to contact when, I have questions. She was very detailed when it came to those things. So I would imagine that this would have been a scam until I couldn't get my money. I couldn't get my payouts. I couldn't get her respond half the time. And then when she did, somehow another, it was my fault that I missed the meeting and that I need to schedule my meetings a certain way and that I'm not a new client. So she doesn't respond to me immediately. And then she was on vacation and then she lived off, her luxury was off of my hard-earned money. The money I have to work 2 jobs for to make sure that I maintain my family and that my son eats. She lived this lavish lifestyle. Like, how dare you? How dare you? Ain't thought one time about how my son hasn't eaten or how I need a new roof for my home. But because of the love of money and greed, she took advantage of me, of our friendship, of our familyship. And that's how she was able to scam me until she couldn't anymore. So then the conversation stopped. The responses stopped. I couldn't get a reply for anything. So that's how I knew that it was a scam. She even went so far as to say, well, hey, I'll file an insurance claim on your behalf with my lawyer so that you can retrieve your money. I haven't seen a dime of that.
Okay. Speaking of your money and a dime, the district attorney's office has listed you for restitution of $7,600. Is that the amount you agree with? Okay. Yes. All right. Ms. Palmer, I appreciate you being here again. You have been available in the past. I appreciate you sharing what you just shared.
Thank you for hearing me.
You're very welcome. Before I go on to the next one, I need to understand, Mr. Wooten, the fine in the notice that you provided. Hold on, let me get this up here. The fine is a very large number that seems larger than all of the restitution combined.
Yes, Judge.
I trust you've discussed it with Mr. Ford, but where does that, it's down to a nickel, 2 million plus down to a nickel.
So under the RICO statute, the fine is up to 3 times the pecuniary gain. And so that's all of the restitution added up together times 3.
Times 3. Got it. So it's a statutory maximum fine.
Yes.
That's suspended if Ms. Brown and if there are co-defendants who are jointly and severally liable, if they all pay everyone back.
Yes.
Okay. And the state would in no way try to collect fine before restitution.
Absolutely not.
It would be a junior obligation. Okay. Janique Turbe, and I apologize if I mispronounced your name.
Judge, she did submit a written statement.
Great. Ms. Turbe is fine for that to be read into the record, and we'll probably do it now unless there's something that you want to say.
I just would like to add, hold on, let me put the camera on.
Can I have
I just would like to add that
Can you spell your name for the court reporter, please?
Janique, Janique, and my last name is Turbe, Turbe. I would like to add, Judge, that I was also under a false pretense. I saw other service members sending money, and she would post it on Instagram and say that they received their money back. I was just notified last year that I would be losing my security clearance because I took out a USAA starter loan because I cannot pay it back. I took out a starter loan, and Kayla knows that I took out a starter loan to start investing to at least bring generational wealth because I have a 4-year-old. I cannot stress this enough that I continuously reached out to Kayla and she blocked all communication. I continuously told her that I needed my money. I needed to start paying my loan back. She did not care. She cut all communication. She blocked me on Instagram and she continued to live her lavish life. This is my career at the end of the day. I'm a National Guard, but I'm also a police officer. I cannot get dishonorably discharged. I feel like she needs to serve the maximum amount of sentence. She does not deserve any leniency. She does not deserve probation. She does not deserve to see the outside of jail. She took all of these people money, over $25,000 from me, just alone. That's all I have.
Well, Ms. Turbe, that's plenty. I appreciate you dialing in. I appreciate your service. How was it that you knew Ms. Brown, or how did you come into her orbit such that you decided to invest with her?
I saw her on Instagram and I reached out to her before I even sent her any money. I asked her a whole bunch of questions. Was the business legit? And everything under the sun. She proved to me that from my belief, she said that it was. She sent documents saying that it was. The Gail Octum person, when it was time to get my money, that's who I was reaching out to constantly. Another person, Rachel Kemp, and it was just crickets. I heard nothing.
So she was a stranger to you initially, and you learned about her through Instagram.
Correct.
Got it. And what state are you based in?
I'm in Georgia.
You're in Georgia. Okay. Last question. You are listed as entitled to restitution of 24,000 and some change. It's a little different from what you said, which was 25,000. I just want to make sure there's not a misunderstanding because I'll be entering a final disposition in Ms. Brown's case and in theory in the other two cases, and I want the restitution amount to be accurate. And I'm assuming when the prosecution put that number in, it was based on the records that they were able to recover. Does that sound like it's in the right ballpark for you?
It does.
Okay. All right. Do you want Mr. Wooten to read into the record what you wrote, or do you feel like our exchange sufficiently conveys your frustration and outrage and the impact it's had on your life and your son's life?
I feel like it has, sir. I feel, Judge, I feel like he doesn't need to read it.
Okay. Well, I appreciate you making yourself available for this. I hope you weren't driving while we were talking.
I pulled over.
Good. I'd have to arrest you as an officer. So, you get back to work. Thank you for your time.
Thank you, Judge.
All right. So next is Jordan Cherry. I don't think I see a Jordan Cherry. Anything written from Jordan Cherry?
No, Your Honor.
That is a little under $19,000. I'm not interested in participating. Didn't say I don't want my money back. Okay, thank you. That gets us then to Kaylin Usher. I see Ms. Usher here. Ms. Usher, do you want to speak?
Yes, I do.
Okay, well, we'll wait till your camera's on. I'll add you. There you are. If you could get to a standing still spot and then spell your name for the court reporter, I'd like to hear from you.
Name is spelled Kaylyn. Sure,
Okay. I'm ready.
So I just want to say, this situation has impacted my life tremendously. I'm suffering mentally and and financially. Kayla stole over $15,000 from me. I liked her in the beginning, and this is long awaited. I've been waiting almost 5 years now. Um, yeah, I'll never trust anybody again talking about a stock. I don't trade or anything like that. I'm paranoid when it comes to trading. So yeah, I'm glad we're here. I think life in prison is more of a fair consequence, but knowing that she will have to do a few years in prison and spend a little bit of time away from her children is fine by me.
Okay. I haven't asked the others, and I'll maybe periodically ask it of people. But you are hoping to be paid back, and I've got you down as just under $16,000 that you're owed in restitution. You understand that any ability Ms. Brown might have to repay restitution would be delayed as long as she is in custody. So
Correct.
if you are asking for her to go away for a long time, she's not gonna make any money while she's in custody. So that delays you regaining any of the financial loss that you've suffered. Does that impact at all what you think the outcome ought to be?
Um, a little bit, just a little bit.
Okay. But you understand there's a balancing act of, sure, one could say, we'll see you in 15 years. And then who knows what her earning ability would be after 15 years in custody, as opposed to maybe you go away for some time, but the sooner you're out, the sooner you have an ongoing legal obligation to pay back. Because I've heard some people say, I'm going to sue, and that's fine. That costs money to sue someone. Maybe you win, maybe you don't. Restitution is a pretty ironclad legal obligation that you don't have to sue anyone to get. But no one's paying restitution while they're locked up. So you can see the kind of thing I'm trying to balance as well. But I think you understand that. How did you know Ms. Brown such that you ended up investing with her?
I came across her through a friend of mine. In high school, I was fresh out of high school, and I was looking to invest some money, a couple of $1,000s that I had. A friend of mine put me in contact with Kayla. Kayla was advertising the fact that she was a stockbroker and that she was very heavy in the trading industry here in Atlanta. It was between 2020 and 2021. So trading was very big out here. So I contacted her and I was trying to learn to trade. And that's where it started in November of 2020.
Okay. All right. Well, Ms. Usher, I appreciate you being here. Thank you for your time.
Thanks.
Keontae Colton is next. And I'll rely on you to chime in if you've heard from a victim, ma'am, that they're not interested. All right. I don't see him on. So we will continue on down the list. Ms. Bell, I have seen Ms. Bell on. Ms. Bell, do you want to be heard? Thought I saw Ms. Bell on. Nope. Okay. Lexus Reeves. That's our $940 one. Okay. Miles Abrams. The Butlers.
Yes, Your Honor, we're here.
Hey, Mr. Butler, tell me how you want this to work. You and I'm assuming Kathy's your wife?
Yes, that's correct. And I'll be reading a statement from both of us, sir.
Excellent. Okay. Let me get you on the screen here. I think Ms. Rivers can spell your name, pretty standard spelling. Mr. Butler, I would love to hear your statement, and then if you could include in there, either at the beginning or the end, how it was you came into contact with Ms. Brown so that you ended up getting ensnared in this scheme.
Yes, sir. I'll start with that. My wife met Ms. Brown and her mother first, and she invested with Kayla and referred Kayla to me. And then she reached out to me and said that she heard I was interested, and I invested from that point forward.
How did your wife know Ms. Brown's mother? Was that the connection, or what was your wife's connection to global investments?
I don't. Kayla was a family member of a family member. That's how she met her.
Okay, got it. But ultimately, you and your wife were both pouring money into this.
Yes, sir.
Okay, I'm ready for your statement.
All right. I wrote it down, so I'll be reading it. Kayla was cold and manipulative. She mercilessly demanded more and more money. Every time we were led to believe that would be the last step needed to deposit the funds from our investment into our accounts. We explained the hardship that was caused by the delays and the additional funds demanded of us time and time again. This corrupt family, the three of them, has to this day shown zero remorse for bleeding all the victims, known and yet unknown, of hundreds of thousands. Now we know it's at least $600,000, probably much more, with the unknown victims. I hope that Your Honor sends a message loud and clear that criminal enterprises prying on vulnerable citizens will receive a sentence commensurate to the crimes committed. That's all I have written, sir.
Thank you, Mr. Butler. That was plenty. I appreciate you sharing that. I'm sorry for the loss that you and your wife have experienced as a result of the scheme. The paperwork I have shows that the two of you combined are out just under $57,000. Does that sound correct to you?
That sounds about right, Your Honor. And I'll forego some of that funds to have them spend a lot of time in jail, to be honest.
Okay, I appreciate your trade-off. Thank you, Mr. Butler. Mr. Wooten, every once in a while someone says something and that leads to more questions for you. Mr. Butler referenced unknown victims. From your work and your investigators' work on this case, is there a reason to believe that there is a greater loss out there and that there are people who aren't going to be, insofar as restitution makes people whole? I know it's not a perfect system, but are we missing things in this universe?
Judge, there might be a couple. There's a few names that I saw in the like the Zelle records and the Cash App records that popped up here and there, but multiple agencies worked on this case, including other states. And so we've thoroughly tried to contact every single person. These represent all the people that have participated in the prosecution. So there might be others, but if there are, I don't know that it's a substantial amount.
Sure. It's not many people and it wouldn't be a ton of money or they'd be speaking up. What about my 100 grand?
I believe that's fair.
Okay, got it. Thank you. Next up is Shan Thomas.
Good afternoon, Judge. I'm here.
Hey, Ms. Thomas, let me get you on the screen. One second. All right, there you are. Good afternoon.
Good afternoon. First of all, my name is Shantanya Thomas, and I would like to read my statement. Is that okay?
Sure. Can you spell your first name for the court reporter?
Sure. SHANTANYILA. Last name Thomas, THOMAS.
Got it. I'm ready when you are.
All righty. Your Honor, there's a moment I have carried with me for a very long time. It was the day I walked across my high school graduation in 1992. I really didn't know if my mother would be there. We didn't know where she was. But what I did know, what I held on to that day, was that when they called my name, Miss Brown's family was going to cheer for me. And they did. This is who Kayla Brown's family was to me. Miss Brown knew my story. She knew I came from the Zone 3 projects of Atlanta. She knew my mother struggled with addiction. She knew I had very little family support. She knew I was once a homeless teenager who slept on the floor of her mother's bedroom for years. before later having to enter into a homeless shelter. She also knew how hard I worked to pull myself out of that life, to go to college, to build a corporate career, purchase my first home, and create stability for my children. She witnessed the journey firsthand. This is what makes the betrayal so devastating. And I want this court to understand the full weight of what was taken from me. So beginning in 2019, I continued over several years. Ms. Brown repeatedly came into my home and my office, looked me in my face, took thousands of dollars from me, and assured me that she would never harm me. I asked her directly, Kayla May, am I being scammed? I gave her multiple opportunities to tell me the truth. Each time she chose to lie to my face. Each time she chose to continue to defraud me. In 2021, after realizing I had been completely taken advantage of, I hired my own attorney and I filed a civil suit against Ms. Brown. What is especially disturbing is that she didn't deny receiving my money. Instead, she formally responded to the court claiming she had been investing on my behalf. That claim now sits on record. It is false and it misrepresented the attempt to legitimize years of deception after the harm that already occurred. The fact that this response was handwritten and submitted without remorse demonstrated a continued willingness to manipulate the truth, even in a legal setting. This was not a misunderstanding or a mistake. It was a deliberate effort to reframe theft as opportunity, even when faced with accountability. The emotional impact of this experience has been overwhelming. It took me more than a year to process the betrayal, the shame, and the heartbreak. I sought therapy and support groups simply to regain my sense of stability. I questioned my judgment and my worth. When I eventually reached a place of forgiveness in order to survive what this did to me, but it doesn't erase the harm. Your Honor, my mother grew up in this city. She drank from colored-only water fountains and entered restaurants through the back door. I am a first-generation high school graduate, a first-generation master's degree recipient, a first-generation homeowner. Every financial milestone I have ever reached was fought for and clawed to get out of poverty, from homelessness, from a lineage that was systematically denied access to wealth. This money wasn't something I could absorb losing. This was everything. I have since learned that this is called an affinity crime, much like the Bernie Madoff case. It could only occur because of trust, proximity, and love. Had Ms. Brown been a stranger, she would have never had access to my resources. The exploitation of that bond truly altered how I view relationships and trust. Every person she targeted has someone who knew her. Every person she targeted was someone who knew her, who trusted her, and looked like her. But I want the court to understand something important. We are not your typical families with financial cushions, financial advisors, and financial infrastructure to rebuild. We are still building. For many of us, what she took was not a portion of our wealth. It was the foundation of it. She didn't just take money, she stole time we can't get back and the progress that it took decades to make. And Your Honor, with my civil suit and this criminal case already filed, she called me around this time last year, asking me for an EIN number for yet another scheme, claiming that there was $84,000 waiting in an account from a shared Amazon business that really never existed. I recorded that call. I know y'all can't take it, but I recorded. She knew I had an active legal case against her. She knew about this case, but she called me anyway. That call, made with a pending criminal case and a pending civil suit, tells this court everything it needs to know about who she is and what she'll continue to do if given an opportunity. I really have reached a place of forgiveness, not for her benefit, but for my own survival. But forgiveness is not leniency. It does not minimize what she did or erase what she intends to keep doing. Your Honor, I have been carrying this for years through the betrayal, the civil suit, the therapy, the silence. from people I once loved in the family, and now we're finally here. I'm respectfully asking this court for maximum sentencing, not out of bitterness, but out of certainty. This is not a person who made a mistake. This is a pattern, deliberate, systematic, and ongoing. And without serious consequence, there is no reason to believe it will end with me or anyone else. Thank you for allowing me to be heard.
Ms. Thomas, thank you for sharing those thoughts, and congratulations on all that you've achieved from where you started to where you've landed. I'm sorry you encountered this obstacle on your way. And I appreciate the note of forgiveness, which is not the same as leniency. I think that puts your heart in a healthier space right now. And I hope others are able to move in your direction. Tell me how you came into contact with this investment non-opportunity.
Well, same as everyone else has said, I followed Kayla online. I saw that that she had a level of success. I talked to her. I asked so many questions, and she had a story for every question asked. So when I asked about how did she get involved, how did she learn what she was doing, what was it actually, she had paperwork. She had email, she had paperwork, she had documentation, and the story that she told me made sense. She told me that when I know that she had the investment from her father, and she told me that she almost lost it all, and she met a guy at JP Morgan or one of those big financial services companies, and he pulled her to the side and taught her how to invest in these private stock options, and that he ensured her that she would never be broke, and he taught her everything she needed to know. He trained her in stock brokerage and certified her as a stockbroker under his company. She told me that her clientele were the ones that he would send to her because they were not according to they weren't big enough for his firm. Now I have some experience in working with financial services and insurance companies, and that is something that I've heard before. When I met Doug Andrews in Utah, he told me, if you don't have $5 million, you don't even call me. 5 million is the minimum. So when she told me that this particular stockbroker would give her the people who won settlements in law crashes, and when they had lottery settlements and they only had $50,000 or $100,000, it was pennies to him. So they would pass them to her. That made sense to me. And she told me that she was investing in private stock, sports teams, and how California homeowners, and she had looking like legitimate paperwork. And like I said, Judge, I have been reading financial books all my life, and it is by far one of the hardest things to understand. So when someone that comes to you, where you see the level of success that they have visually, and they have a story that kind of makes sense and matches what you've already experienced a little way, and you trust them because I've held her as a baby. Me and her mom were best friends since 13 years old. I have watched her grow. She has spent a night at my house. We went on trips together. Our family was deeply entwined. Entwined. She comes from a family of hard-working women who love hard, women who go to church. I know that she know better. So I had no reason to doubt that my little niecey was going to take care of me. I had no reason. I never asked for any of the money out because I have a business, have a way to make money. And she told me that it would take years for this to matriculate through until COVID. COVID was when I noticed that there was nothing able to come out. And even then, there was a level of, okay, I understand. Oh, it's COVID. Everybody's closed down. So that bought time to 2021. This has been years of financial manipulation. Even on top of that, it's like the other young lady said with, okay, you can get your money out. I'm gonna give you $500,000 of the money out, but you have to pay another $7,800 to get it out. It was all of this continuous manipulation. And I know it's not admissible, but I have YouTube videos of her brokering deals. I have recordings of her asking me for the EIN number, like recently. So this is something that she does. It is.
Well, Ms. Thomas, this has been very thorough and helpful for me. I want to make sure there's not a disconnect between what the district attorney's office thinks your loss is and what you've put next to your name on Zoom. You're listed in the restitution category as being owed $107,000 and some change. You got 157 on the screen there. I don't want to get between you and the prosecutor, but what is being requested that I put in the final disposition, meaning the sentence for Ms. Brown, is that she is obligated to pay you restitution in the amount of 107 and some dollars.
That's fine. We lost the first initial payment that happened in Orlando, Florida. I gave her two cashier's check. Really, I believe it was 60,000. I believe it was a $40,000 cashier's check and a $20,000 cashier's check. We walked into the bank together, and we can't find record of that in 2019, but it was in
Okay.
October of 2019.
Got it. So,
And I'm
so
okay
it's,
with that. I'm okay.
okay. So that your number ties in with what you know you've paid, but in terms of what we can document, since it needs to be proven, it's the state's number. Okay.
Thank you.
Thank you, Ms. Thomas. All right. Next is Sherna Simmons. Don't see her. Sophia Dixon. Tanisha Brown. Tiana Woods. Okay. Tony Burbridge. I've seen your name on there. There you are.
Yes, sir.
Good afternoon again, Ms. Burbridge. Good to see you.
Hello, Judge McBurney.
Hello.
Oof. Man, listening to these testimonies is just, it's heartbreaking. I was not gonna cry but the service woman, that she's gonna lose her security clearance and her career.
I think she's already lost the security clearance. Now she's worried about dishonorable discharge. I mean,
that's money. That's money. You can't equate money to that.
Yeah.
And being a service member, So I'm going to read my statement. I believe, Will, it's in the records, right? My written statement.
I don't know that I have the written version.
That's fine. My name is Tony Burbridge. It's spelled Toni Burbridge. I came into contact with Kayla Brown via Sean Thomas. Sean is a very good friend of mine. And as everybody else has recounted the stories, basically, Kayla's a slick talker. She knew the terminology. I got looped in based on just that she kind of knew what she was talking about a little bit. And same thing with the Gail Octum and the emails. But the harm inflicted was intentional, calculated, and sustained. These actions were not mistakes, lapses in judgment, or acts of desperation. They were deliberate choices made repeatedly with full awareness of the damage being caused. The defendants knowingly stole money that represented years of discipline, sacrifice, and careful planning. These were not discretionary funds. They included retirement savings, college funds, and essential financial resources directly tied to long-term stability and security. These crimes were perpetrated over an extended period and involved multiple victims. Based on the scope, duration, and methods used, it is reasonable to believe that, as stated before, additional victims may exist, who have not been identified or have not come forward. This reflects an organized and predatory pattern of behavior, not an isolated incident. It is important for the court to consider the length of time it has taken for this case to reach this point. The initial criminal theft that impacted me occurred in July of 2020. For nearly 6 years, I and the other victims have lived in the consequences of these crimes while the defendants remained unaccountable. During this prolonged period, the burden of loss, instability, and uncertainty rested on the victims. The passage of time has not lessened the harm, it has compounded it. For me personally, the devastation has extended far beyond financial loss. The crimes place my future, as well as the future of my children and my children's children, at risk. The fragility created by near financial devastation cannot be overstated. When resources intended to protect generational stability are stripped away, the harm ripples forward, threatening not only the present, but decades of responsibility, planning, and stewardship. The emotional and psychological impact has been profound and enduring. The betrayal inherent in these crimes forced me into a state of constant vigilance and distrust. To regain stability and function, I have had to engage in therapy and professional coaching to work through the trauma and rebuild a sense of safety and trust. This process required additional time, effort, and financial resources. The theft did not end with the money that was taken. It continues to extract a cost. What makes these crimes particularly egregious is the continued absence of remorse and accountability. This includes conduct observed in prior court proceedings where patterns of deflection, misrepresentation, and minimization were evident. This was not a momentary lapse in judgment. It was a sustained pattern of deception, exploitation involving multiple victims. The defendant's history also reflects a longstanding reliance on public assistance and taxpayer-funded systems, rather than sustained lawful employment. This is not offered as moral judgment, but as relevant context. When criminal conduct is layered onto this pattern, the financial burden is shifted not only onto victims, but onto the public as well. In this nation, opportunity is available for those willing to pursue it. I know this personally. I relied on public assistance early in my life and chose a different path. Through education, sustained effort, and lawful work, I moved off the welfare system and built sustainability for myself and my family. The availability of opportunity makes defendants' conduct more troubling, not less. Their actions reflect not a lack of options, but repeated choices to exploit rather than take responsibility. Instead, the evidence shows the stolen funds were used to support an extravagant lifestyle while victims absorbed financial loss, instability, and years of recovery. The defendants traveled extensively, spent exorbitant amounts of money, drove luxury vehicles, and underwent elective surgeries, all of which were publicly displayed on social media. These choices reflect conscious prioritization of personal indulgences over lawful conduct and accountability. Any hardship now claimed must be viewed in the context of these decisions. Mitigation cannot be based on circumstances the defendant created through their own sustained criminal conduct. The crimes also present a clear ongoing public safety concern. They demonstrate a willingness to repeatedly exploit trust for personal gain. Given the length of time over which these crimes occurred, the number of victims involved, the lack of accountability shown, and the unlikelihood of meaningful restitution, there is no reasonable basis to believe this conduct would not continue without significant intervention. For these reasons, I strongly oppose any form of leniency. Justice in this case requires consequences that are firm, substantial, and unambiguous. Anything less than the strictest sentencing permitted under the law would fail to reflect the seriousness of the offenses, the intentional and prolonged nature of the conduct, and the compounded harm caused by the years of delay and the ongoing risk posed to others. In addition to incarceration, full financial accountability is essential. I'm going to end it there. However, what I would like to say is that we have served the sentence time adjacent, all of us. If you look at it compounded and across all of us, it's 144 years. So a full sentence, a life sentence, although probably unlikely, would not be unheard of. I oppose a first offender, and I believe that 20 years would not be unheard of or more due to the fact of how this crime was perpetrated against so many victims And I highly doubt that she would not do this in the future. So would I like my money back? Yeah. Would I rather her sit and rot in jail? Absolutely. Do I forgive? Yes, but there are natural consequences in this world for what you do to people, especially God's people. Thank you for hearing me. That's all I have to say.
All right. Well, Ms. Burbridge, I appreciate you sharing those sentiments and highlighting what this has done to you and emphasizing the things you've heard from the others about the ongoing impact that this has had. I appreciate you being here.
Thank you.
Ms. Dixon is on the call. She chose not to speak. I let her know what her restitution amount was. She put something in the chat, but indicated she's here and is listening. Doesn't need to be heard. Just wanted to know that she was here. Okay. Brandon Bell. Desmond Heath. Gary Witt. There's a Moffat who is on. There's a Moffat on the list. I don't want to mispronounce the first name. So if Moffat wants to be heard, if you could unmute. All right, we'll keep moving. Ms. Gant or Mr. Gant? There's a second Moffat, Kevin Moffat. Two Moffats. Either Moffat want to be heard?
No, that's okay, Your Honor.
Okay. Are you the Kevin of the Moffats?
Yes, both.
Okay. Thank you for being here, Mr. Moffat.
Mm-hmm.
Kenya, well, we've got three Lukes. So I don't know. I know Kenya Luke is on. We got all three Lukes who are on. Do any of the Lukes want to be heard?
And Judge, I do have a written statement from Miss Kenya Luke.
Okay. I'm not seeing them activate, so why don't you share Ms. Kenya Luke's statement?
Sure. For the past 8 years, my family and I have lived with the consequences of fraud during one of the most vulnerable periods of our lives. I was a recent high school graduate at the time, doing everything I could to help my mother, a widowed parent raising 6 children on her own. Wanting to ease her financial burden, I believed I had found an opportunity that could improve our situation. I trusted Kayla and genuinely believed I was making a responsible decision for my family's future. Because I believed that the opportunity was legitimate, I shared it with my mother and my sister. Instead of helping us, it resulted in all of us becoming victims of fraud. What we hoped would be a step towards stability became the beginning of years of stress, confusion, and emotional exhaustion. Throughout this long process, we have dealt with broken promises, false reassurances, and repeated attempts by the defendant to minimize her role in the harm that she caused. Lawyers reached out to us but never followed through. The defendant contacted us multiple times, claiming that our money was, quote, ready and available, only to insist that additional fees had to be paid first. Each time, our hope was raised and then immediately taken away. Another layer of harm came from the way the defendant chose to communicate. She consistently reached out only to me and rarely contacted my mother or my sister. She claimed she had a, quote, better business relationship with me because I had been investing longer, even though I was barely out of high school. This selective communication placed an unfair emotional burden on me and created a false sense of responsibility for the entire situation. We were told that multiple stocks and investments were being managed on our behalf. The defendant had access to our banking information and repeatedly changed her explanations about how our supposed returns would be delivered. At one point, she stated the funds would be sent through an ACH payment. Later, she claimed an overnight check would be mailed and would need to be picked up from the post office and signed for. None of these promises ever materialized. Instead, she began quoting numbers that were well into the six figures, figures that only deepened our hope and ultimately our disappointment. During this period, My mother was still caring for 4 children who were in school. We trusted that investing in stocks and bonds through the defendant, someone we believed was acting as our broker, would relieve some of the pressure my mother carried every day. Instead, it added to her stress and left us feeling betrayed and taken advantage of. Workdays felt long, but none of that mattered to Kayla, who continued to mislead us despite knowing the hardship we were already facing. This journey has been overwhelming, a constant cycle of frustration, emotional strain, and disappointment. What we wanted was simple, to put our family in a better position. Instead, we were exploited at a time when we were trying our hardest to build a stable future. The impact of this fraud has stayed with us for nearly a decade. It has affected our trust, our financial security, and our peace of mind. After 8 long years of waiting, hoping, and being misled, we are simply asking for what is rightfully ours. We want the funds that belong to us, nothing more, nothing less. Receiving what we are owed would not erase the emotional toll, but it would finally allow our family to move forward with closure, accountability, and the stability we were promised from the beginning.
Thank you for sharing that on behalf of Kenya Luke. Lynette Luke indicated that she submitted a written statement and would like that read as well.
Good afternoon, Judge. Ilona Rolak here.
Oh, Ms. Rolak coming in from the side. Yes, ma'am.
I do have Ms. Lynette Luke's victim impact statement.
Okay, let me get you on the screen. There you are. Good afternoon. If you could please share what Ms. Lynette Luke had to say.
Your Honor, my name is Lynette Luke, Lynettee, and I am submitting this victim impact statement to explain how Kayla Brown's actions have affected my life and the lives of my 6 children over the last 7+ years. I'm a widowed mother of 6 children. When my husband, their father, passed away so suddenly and unexpectedly, our lives changed in an instant. The loss was devastating and overwhelming. Along with the grief of losing my husband, I was left carrying the responsibility of raising and providing for our 6 children alone. There were many moments when I truly did not know how my children and I would survive after losing him. I was grieving and trying to stay strong for my children and doing everything I could to keep our family together while facing a future that felt uncertain and heartbreaking. During one of the most vulnerable times in our lives, Kayla Brown entered our lives, became close to our family, and built trust with us. She convinced me that she would guide us on the right path toward financial freedom and stability. She made me believe that she was helping us build a better future, one where I would not only be able to financially support my children day to day, but also prepare for their futures and their dreams, including the opportunity to attend college and have the stability every parent hopes to provide. Part of how she gained our trust was by connecting herself to our grief. Kayla Brown told us that she had also lost her father at a young age, and that because of that, she understood exactly how my children felt and what they were going through after losing their father. She presented herself as someone who understood our pain on a personal level and someone my children and I could trust because she had experienced similar loss. As a mother trying to help my children through one of the most painful times in their lives, that meant a great deal to me. I believed she understood their heartbreak and truly cared about their well-being. Looking back and realizing that our grief and my children's vulnerability were used to strengthen her relationship with our family and gain our trust had made this betrayal even more painful. What happened to my family was not a misunderstanding or a one-time mistake. Kayla Brown stole from my family, scammed us, and preyed on our hopes for a better future and the financial security I was trying so hard to create for my children. She gained our trust during one of the darkest times of our lives and then used that trust for her own benefit. The impact of Kayla Brown's theft, deception, and fraud has followed us for the last 7+ years, more than 84 months, more than 365 weeks, and well over 2,500 days. During that time, my children and I have lived with financial hardship, emotional stress, and pain that continues to affect us. What she took from us was more than money. She took opportunities, peace of mind, and the sense of security I was working so hard to create for my children. What made this especially painful was the continued dishonesty and manipulation. There were repeated lies and patterns of deception over time. I believe Kayla Brown involved members of her family and others as accomplices to continue the scam and make everything appear believable and trustworthy. Rather than being honest or taking responsibility, the deception continued. Every lie added to the damage and made it even harder for my children and me to recover. Over the years, while my children and I continued struggling to make ends meet, I watched Kayla Brown benefit financially. I watched her purchase vehicles, homes, and other things while my family continued to survive and move forward. While we were working hard, grieving, sacrificing, and doing everything we could to stay afloat, it was incredibly painful to witness her lifestyle grow while we continued to struggle with the consequences of what had been taken from us. The deepest betrayal as how she used was how she used my husband's death, my children's father, as a way to connect with us and gain our trust. My children had already experienced the devastating loss of their father. To have someone enter our lives during that grief, present herself as someone who understood our pain and cared for about our future, and then use that relationship to deceive us has caused lasting pain and has deeply affected our ability to trust others. My children have not only had to carry the grief of losing their father, but they have also had to witness the financial strain, emotional stress, and hardship caused by Kayla Brown's actions. I respectfully ask the court to consider not only the financial loss involved, but also the emotional harm caused by the deception, the betrayal of trust, the use of our family's grief, the involvement of others in continuing the scam, and the lasting impact this has had on me and my 6 children. The harm has been deep, painful, and long lasting, and it is something our family has carried throughout the last 7+ years. Thank you for allowing me to share how this has affected my family. Sincerely, Lynette Luke.
Thank you, Ms. Luke. That concludes the list of listed victims in the sentencing notice. Is there anyone on the Zoom call who was expecting to hear their name called, who wanted to be heard?
Your Honor, I'm not sure if I'm on.
Ms. Bragg?
Yes, my name is Jerry Bragg, and I'm actually the mother of Janae Moffitt, who was our initial person that met with Kay Brown and got us all involved. That
Okay.
would be the other Moffitts and Bill. I think there was a group, but I would like for my daughter to speak on our behalf.
This is Janae Moffitt, Geneemoffett is the spelling. And Judge, I'm going to keep it short because I don't have the grace that some of the other victims have. But that group that you called, that was my personal circle. Those were the people that I could call when I needed something, and vice versa. Those are the people that depended on me to make sound decisions because this is something that interests me, and we were all looking for something at this point to be able to benefit our families as everybody else was. And for Kayla and her group to just continue with this elaborate scheme as we questioned, we researched, we reached out, we contacted people. Judge, I feel like we did everything that we could possibly do to vet her, and she came out pretty okay. And for this to come this way, the last email that I have from her is her telling me that she was selling my stock and I should be getting my payout. And for her to just run her business, run her personal life the way she has, I can't respect it. So like the others, I'm not really concerned about restitution at this point, because at this point everything she has should have been frozen. She should have access to nothing the way we have access to nothing. I feel like sitting here and looking at her face, she definitely doesn't have any remorse. She definitely doesn't care. So with that being said, Judge, as much time as she can get, she deserves to get. Right now, my mother is retired and she has to move in with me because we used funds thinking that we were going to add to her retirement and not take away from. Like Miss Palmer at the beginning, second and third jobs are not optional. They're required to try to recoup and try to come back from a mistake that we made. And ultimately, I made because I brought my group to this. When I asked that lady there, Kayla, just make sure you're doing what you're supposed to do. If you got any questions, if there's any issues, just say something. Judge, when she came to us and she said, oh, my baby got COVID. Oh, I just got out of COVID. Oh, I'm in New York. My daddy had a stroke. We got all of these excuses. All of these excuses. We got pictures of accidents. At one point, she told my dad that a bird died. That's the reason why she couldn't contact us. So no, I don't have any sympathy for Miss Brown. And yes, if you're asking me, I know my group wants their money back. But if you're asking me, she needs to serve as much time as she can. Let her work her restitution off making license plates or whatever they do now. Because that's what it feels like that we're having to do. Those of us who's having to work 2 and 3 full-time jobs to recoup the money that you knew you were taking from us, and you knew that you were not investing and you were spending on whatever you were spending it on. So again, Miss Brown, I'm glad to see your face.
So Ms. Bragg, talk to me, not to Ms. Brown, okay?
I'm glad to see your face here. I'm talking to the judge. Judge, I'm glad you're allowing us to see her face so we can put a face with the BS that she put us through, with the strife that she put us through. I need her to know that this was not ever going to be just as simple as she thought it was. Because when I filed that case against her, I meant every word that I told Agent Miles. Every word. And if we could, I would want my restitution in blood.
Okay. I appreciate you sharing what you're sharing. Like you forecast, this was going to be a little different from other people's presentation.
Thank you, Your Honor, for your time.
I want to know what our group total was.
I don't know when you say group what you're talking about.
We invested as a group. So what's the restitution amount for if since we don't have a group total, what's my restitution amount?
$78,210.
Correct.
Now there's a Kevin Moffitt in the mix. And so when you say group, a whole lot of names here. If you want to give me some names,
right. Kevin Moffitt was in the group.
He's 17,761.
And Janelle Moffitt?
Nope, that's not in there. There's you and there's Kevin Moffitt.
Judge,
okay,
I can explain.
Brandon Bell?
Yeah, why am I? You know what? I'm going to share with people their numbers. You got your number and you are all set. Thank you. All right. I have one more question for you, Mr. Wooten. If you don't have anything you want to add in summation now that we've heard from everyone.
Just the only thing I would clarify on that restitution question is a lot of the folks connected to Miss Moffitt, they would provide the money to her and then she would provide it to Kayla, which is why it's broken out the way that it is.
Understood. It would help me as I'm thinking about things when Mr. Ford makes his presentation and Ms. Brown says whatever she's going to say, if she chooses to. If I had a better understanding of the state's perspective of the relative roles of the three people involved. Most people who have talked about their experience and loss and hardship have focused on Ms. Brown. There have been a couple references to, I believe it's her mother and her uncle. Is that the biological connection? But only in passing. All three are indicted. You said something about jointly and severally liable and all that. Would you, if you were given your opening statement,
Sure.
you don't need to, but how would you characterize the respective roles? And in particular, if there's someone who you would view as more culpable and liable for these losses and the impact that these losses have had?
Sure, Judge. Based on the evidence, it's the state's position that Ms. Brown is far and away the most liable, most culpable party, far and away. The way that we broke down the indictment was based on primarily the financial transactions and who money was going to, how much, when, and where. But the overwhelming majority of it went directly to Ms. Brown. A significant portion went to Mr. Jones.
And Ms. Jones is only in she's obviously in the main count. She's only in a handful of the other counts.
Well, but it's my understanding, based on speaking with victims, that she was physically present more than Mr. Jones ever was. So I would say that state's perspective is that Kayla Brown by far the most culpable, Mr. Jones second, Ms. Jones third, based on the evidence that we have and what we would anticipate proving at trial.
And in talking with any of the victims, did they describe either Mr. Jones or Ms. Jones as people who also sold the scheme? Because it sounds like, I very clearly heard it, Ms. Brown was very much the front face of it. Here's why you should do this. Here's paperwork. You should trust me. I feel your pain. I lost my father too. All those. Did you hear from any of the victims that actually I got involved because I was tight with Mr. Jones, and he's the one who was most persuasive?
No, the state's understanding of the evidence and speaking to victims is that Ms. Brown was always the front person.
Okay. All right. Thank you. Mr. Ford, I turn to the defense. Tell me how you'd like to proceed.
Let Ms. Brown take the stand now.
Okay. And you want her to take the stand? I mean, she's kind of already under oath because she is under oath. Mr. Wooten put her under oath. You just, in order to interact, so you're not sitting next to her while you ask her questions? Okay. So Ms. Brown, if you come on up here and take the stand. And the chair does not have wheels, so it's kind of hard to move, but you're going to need to move it and you're going to need to bend the microphone because the court reporter is going to need to be able to hear what you have to say. Okay, great.
And Ms. Brown, it's my understanding that when you hired me, it was your understanding that your restitution amount was 300.
Yes.
We've discussed that today, right?
Yes.
And now learning that the number is $600,000, that does not change, or does that change your decision to enter into plea of guilty?
No.
Can you tell the court how this began?
It started I had a wrongful death lawsuit from my dad, and I was giving some money young, and basically the lawyer who represented us sent a financial advisor to my mom's house when me and my brother first got the money, and he sat at our dining room table, and I was a teen parent. I had a young daughter then. He told us, we need to invest some money. He was like, when you come into money like this, you become everybody's scapegoat. He was like, you need to invest your money or whatever. Your brother, he got all his. You need to make sure you're doing this, that, and other. So I started doing so.
Why did I'm sorry to interrupt, but I want to make sure I'm following things. So your father passed away. What happened? Was it a car accident, a work accident?
No.
What happened?
I don't want to cry up here because I don't want them thinking that I'm crying because
Don't worry about them. They've already spoken. They're done talking. It's your turn.
my mom and my dad, they got a divorce and they had a child support agreement. And I was a troubled teen. So me and my mom, we used to go at it. And when I turned 13, my mom finally said that I could go stay with my dad and my brother stayed with her, but they never did the agreement on paper through you guys. So they had a court hearing. I moved in with my dad and they had a court hearing. And my dad came to court and they said that he had a warrant for child support and they arrested him and he went to Rice Street and they basically mistreated him. They wouldn't let him call us. 10 days later, my uncle called my grandma and told her that my dad was found dead under a Fulton County jail cell bed.
So he passed away at the Fulton County Jail. There was a lawsuit, and the proceeds of the lawsuit went to you and your brother because your father and your mother were divorced.
Correct.
Okay. And ballpark, what is it that did you get a lump sum payment or were you getting a series of payments?
I get lump sums. I started off with lump sums. My 18th birthday was my first one, so every year for my birthday, and then a monthly amount, and then
How much did you get on your 18th birthday?
I don't want to lie. I think 50,000.
Okay, ballpark. It wasn't $10 million. It wasn't $5.
I got 50,000 on my 18th birthday.
And is that pretty much the standard payment? Each year you're getting 50,000?
No, sir.
How does it change?
Some years I would get 100, some years 250. My last one is in 2029. That's for 350,000.
Okay. When is your next one?
2029.
You don't get one between now and 2029.
I get monthlies, but I don't get another large lump sum.
How much do you get monthly?
$2,000.
And then periodically there's a large payment.
Correct.
The final of which is 2029.
Correct.
Okay. Thank you.
Mr. Father, you didn't know he went to court for child support. We didn't know he was diabetic. Is that right?
No, we did know.
And he did not receive his insulin from Rice Street. Is that right?
Correct.
And so counsel representing your family told Mr. Davis, how do you pronounce his first name?
Malawi.
Davis, is that correct?
Correct.
And the settlement was for 1.5, is that correct?
I believe so, yes.
And your father at the time was a bus driver, is that right?
Correct.
And so his income and salary was what, circa $50,000 a year, is that right?
Maybe a little less.
He was 38 years at the time?
I believe so. I'm sorry if I'm looking at my mom. I don't know the exact age. Maybe 38.
And so first payment came in when you were a teen mother at 18 or 19, right?
At 18.
Take us from how you received.
Excuse me, Judge.
Yes, Ms. Rivers.
Counsel, please go to the microphone.
Yes, Mr. Ford. Thank you.
Thank you. Tell us how you went from receiving a six-figure payment from Fulton County to portraying yourself as someone who is sophisticated enough to invest folks' money. Take us through that transition, please.
So I was told to invest and I started investing and it was going really good. And I started becoming the family ATM. I'm 18, I was the family ATM and I told my mom, I said, I don't want to keep, giving everybody money. So I'ma just put them on to how I'm making money so everybody can, make money. And it was going good for a long time. Everybody was, making money and stuff until like it just wasn't. And like I told my mom or whatever, like getting pregnant at 16 and all this stuff, I always was looked at like as a failure and stuff. So this was another aspect where I felt like I failed. So I was trying every way to kind of like pivot to correct the situation until it wasn't a way that I could correct it. It was too far gone.
Kayla, the website,
Yes, sir.
did you create that?
No, sir.
Who did?
Sean Thomas.
And at the time the website was created, did you have any investment experience?
No, not just what I had been doing.
When we're talking about website, is this a website for Global Investments LLC?
She made a website for me to get clientele there. She said like I think she does like business.
What would I have, if I went to the website, would it be about you or would it be about Global Investments LLC?
I believe it was about just me. I didn't handle any of that. So
I'm not asking how it got put together, but did you never go to the website?
not really. I just did the photo shoot. I'm not gonna lie. I was young, just doing stuff.
Okay.
Was the website used to attract potential investors?
Yes.
In what capacity and how?
She did. She told me that she was putting in like client reviews. She was doing like 5-star client reviews and all of that stuff. She set me up a photo shoot downtown, a professional photo shoot. Yeah, she used like big words. I remember a phrase where she told me, you don't go to a hairstylist doesn't say they're a hairstylist, they say they're a cosmetologist. So she was basically saying like I was just putting a professional term on what I was doing.
Your understanding is there's 25 folks, and there may be more, but there's 25 folks named who've given their hard-earned money in electronic transfer to you over the course of about a 4-year window.
Correct.
Right? And what I would like to know, and I think the court would like to know is, besides the familiar connection you had to these folks, what did you personally do, if anything, to attract folks to invest in a teenager or a young 20-year-old mother who had no knowledge of how to invest?
My lifestyle, I've always been really significant on social media.
Hang on, let's drill down on that. What do you mean by that?
I've always had a heavy followers on social media. I've always like posted a lot about my life, the cars, the trips, everything. And people looked at it and they wanted a piece of it.
Let me ask this question this way. I don't mean to leave, but is it fair to say that you used your father's settlement to flash money online? Is that a fair statement?
Correct. Yes.
And by virtue of flashing money online or fronting, you were providing an image of a lifestyle that you didn't really lead.
Correct.
And that was done to design and create the illusion that you were a more successful investor or an investor at all, that you were in fact not. Is that correct?
Yes.
I'm a little confused. I'm following Mr. Ford's questions and your answers. But I thought, Ms. Brown, you started by saying, I did really well as an investor. You got this initial money, and the lawyer said, you're going to need to invest this so that you don't become the piggy bank or ATM for everyone. And I thought you said at the outset here that, and I did really well. I invested, I did really well. But now Mr. Ford is asking, and you're saying, I don't know anything about investing. I'm not good at investing. Which is it?
So I did do really well with my personal investments and like with some of the family and friends too, or whatever. Like I said in the beginning, it was going really good. Once COVID hit, it wasn't. And it was like I was trying to clear up actions, clean up stuff because I didn't want to look like the failure that I had always been.
Got it. And you had hit an investment crisis. Things that had been going well stopped
Correct.
going well. Okay.
So it wasn't like me being malicious. That's not how it was. That's, yeah.
Kayla, were you, I guess really, here's what I'm personally confused about is you either know how to invest or you don't.
Right.
And you're either using your father's settlement money to pay your investors or you're not. So did you know how to invest money and go online and do day trading or not?
No.
Were you using your father's settlement money to pay these folks and just taking money from Peter to pay Paul? Do you follow my question?
Mm-hmm.
Is that what you were doing?
Yes.
So were you really investing money and getting a return and following the exchange? Or were you just taking money from one person and giving it to someone else in a perpetual Ponzi scheme? You know what a Ponzi scheme is?
Yes.
You do?
Yes.
Were you engaged in basically in essence a Ponzi scheme?
Yes.
So you weren't investing at all. Is that a fair statement?
At one point I was, but yes.
Well, let's get to the point of some of, and I'm picking names randomly. I don't know the time flow, but Ms. So Ms. Turbe, she learned about you online, not someone she knew. You're not someone she knew from childhood or this or that, but saw your social presence, social media presence, like you said, and she sent you some money. When she sent you money, would that have been a time when you said, "Great, I'm buying you Amazon stock," or would that have been a time when you said, "Thanks for the money, I'm sending it to this other person because I owe this person some money"?
It was so long ago. I can't tell you the exact exchanges on it. I'm sorry.
That's okay. And I didn't ask it real well, but there was a time when you would tell people,
Right.
send me money, I'm gonna invest it for you, and you're gonna make a lot of money, like I have, it'll be great. But you weren't going to do that. What you were going to do was to take their money, this is the Ponzi scheme that your lawyer just asked you about, to pay someone else who had been really bugging you, where's my money?
Right.
The answer was you had spent it or you invested it poorly, either one, it was gone. And so you would use my money I'm giving you that you say, we're going to make a lot of money in investment to try to pay off this other person.
Yes, sir.
But you didn't tell me, hey, the money you're going to give me, McBurney, I actually got to pay off this other debt. You told me this is going to be a beautiful relationship.
Right.
You're going to make a ton of money.
Yes, sir.
Okay.
And Kelly, you were using, and I don't want to put words in your mouth, but you're using your social presence and the flash that you were receiving some lump sum payments from Fulton County to present an impression online and in person that wasn't real, right?
Yes.
You've heard the restitution amount north of $600,000, right?
Yes, sir.
Which means if you break it down over a 4-year window, it's about $150 a year coming into your coffers, right?
Yes, sir.
Was it a joint family enterprise where you're all living off that 150, all three of you? Just you?
My mom and my uncle, they didn't have anything to do with anything.
What do you mean by that?
Sorry.
Take your time.
Like I told you at my first appearance, my mom, she works 18 hours a day. My younger brother has been staying with me for the last 3 years because my mom works too much to care for him properly. My uncle, he works 7 days a week. It's like some of the most hardworking people I know. If you knew the way that they work, if you knew them outside of this indictment, you would know they had no knowledge, no involvement with anything that was going on. Because if they did, they wouldn't work the way that they do. They wouldn't, you would understand it. So every time I come here, I'm sorry if I'm getting off topic. I feel bad when I gotta look at my uncle. I feel bad when I gotta look at my mom. they try to hold it together for me.
I want to work through a little bit of that because it's going to help me. I need to work with their lawyers and their cases. You heard Mr. Wooten say that what he learned from talking with some of the victims is that when you would be pitching to them, you should invest. It's a great opportunity. You're going to make a lot of money. I'm successful. Your mom was standing right there. And as some of these folks got to know you through your mom, are you saying your mom had no idea that your situation
No.
became a scam, or she knew that but didn't want to get in the way, or how do you explain someone describing a situation where your mom's right there while you're giving your whole sales pitch, and that's a point in time when your sales pitch was fraudulent? It really wasn't going to be an investment.
My mom, she never sat there while I gave a sales pitch. My mom whole standpoint on it from day one was
She did what from day one?
From day one, from the beginning. I'm sorry. My mom whole stand on it was when it was actually going well and stuff. That's your blessing. You need to keep that to yourself. Miss Shawn Thomas, that's my mom's childhood best friend. When she first reached out to me trying to do an investment with me, my mom told me no. She told me no multiple times. I went behind my mom's back and still did it.
Okay.
So that's not true.
Kayla, I'm going to come back to this line, but I want to. What happened to you as a little girl?
I was molested by my first cousin to the age of, I believe, 12.
Beginning when?
I believe I was like 6 or 7.
You mean sexually molested?
Yes, sir.
And then at 13, your father went to court at your mother's request for child support, and 10 days later, he was dead.
Yes, sir.
And it's my understanding that on 2 occasions, you have attempted suicide. Is that correct?
3.
To the extent you're willing to, and or the court finds it relevant, could you tell us when those events occurred?
My first suicide attempt was at age 13. My second suicide attempt was at age 20. And my last most serious suicide attempt was this January of this year.
And in sequential order, what was the method in each instance?
Drug overdose. My last instance, like I told you, I'm in nursing school now, so I knew the effects of overdosing on Tylenol. And I knew that it would shut down my kidneys if I took a certain amount. So I took like 2 bottles of Tylenol. And my mom, she found me. I was in the hospital for about 2 or 3 days. I don't remember the first 2 days because I was out of it. They said they had to like do a whole bunch of different stuff to get the Tylenol levels down. My level was like 4 times what it's supposed to be for a regular human being. And then I was sent to a mental institution.
Your mother is employed in the mental health arena. Is that correct? She's a therapist?
Correct.
Employed with someone else. Is that correct?
Correct.
Have you been diagnosed clinically?
Yes.
With what?
Severe depressive disorder with manic episodes and anxiety disorder.
How often do you see a mental health therapist?
Like twice a month now.
Are you on any prescription medication?
Yes, sir.
What is it?
Sterling. I know it's 3 different ones. I know it's Sterling. I'm sorry, I can't think of the names.
And that's to help with the mood disorder and
Correct.
stabilization of to regulate your moods. Is that correct?
Correct.
Your younger brother who lives with you, he's how old?
14.
There are 3 lovely young children in the hallway outside. How old are those children?
I'm sorry, 9, 5, and 7 months.
The children I'm referring to are yours,
Yes, sir.
and we have 3 different fathers.
Yes, sir.
And do any of the fathers, have they legitimized any of the children?
No, sir.
Do any of the fathers contribute financially?
No, sir.
In the 2 months I've been involved in representing you, what is your current restitution amount in hand right now today?
Meaning what she could pay right now?
Correct.
If I said, hey, hand over all your money.
Correct. What do you have in hand right now to pay these folks back?
Right under $60,000 plus my bond,
And what is that total amount, ma'am?
about $80,000.
That you could tender to the government, and you can show the court on your phone right now today as having this money in an account. Is that correct?
Yes, sir.
And you would and could tender that in 72 hours notice.
Yes, sir.
Kayla, how have you made money the past 3 months, 2 months as I've been representing you to pay these folks back?
Sports betting.
Tell us about that.
After my I attempted to commit suicide in January. I had a public defender and I called her. I kept calling her, I called her, and she told me, I was like, what's going on with the case? Where am I? She was like, oh, I actually just received the offer. And I asked her what the offer was, and she told me the offer. And I told her, I said, I can't be away from my kids. I don't have anybody that can tend to my kids. And she was like, yeah, well, she told me basically like she had some murder cases going on, going to trial, and she had a lot of different things, and that she thought the best thing was for me to do a negotiated plea. And she was like, Judgment Bernie, he'll probably give you like a year or 2 in prison. And I'm like, I don't have anybody to watch my kids for a day. And at that point, I felt stuck. So I tried to commit suicide. And I tell my mom every day, I feel like my last attempt at suicide was probably the best thing that's happened to me in years. When I got to the mental facility, they lined me up with therapists. I finally got to talk about stuff. I finally got on some medications, and they told me I would start feeling the effects of the medications in about 6 weeks. And I remember I had a counseling session with my mom, and I was telling her I felt like a failure and all of this extra stuff. And my mom said, it's because I'm stagnant. I'm so worried about this case. I'm stuck. I'm not doing anything. And it kind of like flipped the light bulb in my head. I've always had a passion for sports. And I got out of the mood of woe is me. I'm a end it all and take the easy way out. And I said, I gotta do something to fix it. I gotta do something to correct the situation. I ended up sports gambling with my savings, and I just started flipping it from there. I sports gambled enough to hire me a really good attorney. Once I hired him, we started coming up with a plan for me to start saving up for restitution.
This would be the real good attorney you're talking about.
Yes.
Okay. Marketing.
And after I would bet every day, and I would tell my mom, like whatever I wouldn't spend money, I would only give like my mom money because I put her in so much debt with my bond and everything. So I would give her money on it or whatever, and everything after that, we put it up. so I can have, money for restitution. And I saved up about $60,000 in a little over 7 weeks.
What have you paid me?
$10,000.
When I was hired, was it your understanding that your mother and uncle were going to be going to trial?
I believe so. At that time, yes.
Is your understanding that that is not their intention now?
I'm not sure as of today. I don't know now.
Is it, I represent the court, is it correct that your mother and uncle, despite their either lack of culpability or de minimis, Latin for little culpability, are still interested in joining and taking on this financial burden with you? Is that correct?
I know my mom was. I know my uncle said he didn't know if he was able to take a first offender or if he was able to take a plea.
Is it, I guess, more precisely stated, if your uncle and mother perceive this honorable court fashions a sentence that allows you to have a future with your children, that you would be, that your relatives, your co-defendants, would be interested in sharing in the financial burden and responsibility to pay this money back expeditiously post haste these 25 plus victims. Is that correct?
Correct.
It's also my understanding that you would here and now under oath tell this court, the state, and the victims listening, and I believe the Lord that you are committed to, that the next payment that comes from the government would go directly towards this fund to pay back the restitution. Is that correct?
I plan to have it paid back way prior to then.
Well, let's talk about that, because in the 60 so days I've been involved, you've been able to legally, through your own initiative and intelligence, acquire $60,000. Is that right?
Yes, sir.
Circa 10% of the amount owed, right?
Yes, sir.
Are you suggesting to this honorable court that if you were, I'm not even going to suggest avoiding incarceration, but if the sentence was structured where the incarceration was on the back end of a sentence, that you would have some lead time to pay down, if not all, of this restitution with the settlement by 29. Is that a fair statement?
Yes, sir.
Are you taking the position that if you could not have this restitution paid in full by 2029, when you get this lump sum settlement, in addition to what you will earn between now and then, that you'll serve whatever sentence, of course, this honorable court imposes with a smile on your face, knowing that's the consequences of your actions?
Yes, sir.
If you go into custody today, what is your best understanding as to what would happen to the, how old's your daughter? The 3 children in the hallway?
9, 5, and 7 months.
What would happen to the 3 children in the hallway?
I don't know.
Well, tell us, because we don't know your family structure. Is there anyone that could take over parenting, caring for, providing for your 3 children?
No, sir. Like I said, my mom, she works 18-hour shifts. If she had to take my 3 children in, that would cause her to have to quit one of her jobs. My mom struggles while working 2 jobs. There's no way my mom can take on 3 more children and they stay afloat.
When you say 3 more, is your mother supporting other people right now?
No, so my mom's son, my younger brother, knows not to take a jab at my mom, but I support my younger brother.
You mentioned that. You said you're caring for him and your 3 kids.
He lives with me.
Right. So your mother works 18 hours solely to support herself, is what you're saying.
So my mom, after After I got incarcerated, my bond, it came up to like $27,000. They had no access to any of my funds. My mom and my uncle, they took out loans everywhere.
But when you talk about your mother's household, her household right now is herself. There are not other dependents in the household.
No, me and my children no longer live there.
Okay.
When I met with you 2 months ago, I met with you in a townhome in Dallas. Is that right? That's your mother's home?
Correct.
And when I met
Dallas, Georgia, or Dallas, Texas?
Dallas, Georgia.
Okay.
And your three small children were there, and your 13-year-old brother was there, right?
Yes, sir.
And you were home caregiving for the 4 kids, right?
Yes, sir.
And you have now relocated to a home in Locust Grove, is that right?
Yes, sir.
And is that because the address that your mother lived in Dallas was part of the public record relative to this event? Is that right?
Yes, sir.
And there was some level of harassment you felt, or some exposure for your kids, which is why you had to relocate. Is that right?
Yes, sir.
With the $2,000 you received from the government and the money you're making online, what is your current overhead and bills to pay your current bills?
Maybe about $7,000 or $8,000.
Your nut, as we say, is $7,000 or $8,000 to pay if you have a car,
Yes.
insurance on the car,
Yes.
and food for the family,
Yes.
and rent.
Yes.
You have insurance,
Yes.
health insurance.
Yes, I have to pay insurance because I'm in nursing school, so I'm required to pay insurance for that. I have to pay $5,500 every session for school. That's my out-of-pocket cost. I have to pay for daycare for my son because I don't have anybody to watch him, and summer camp for my children, so I'm able to go to school.
What kind of car do you drive?
It's a Toyota Camry,
What year?
2025.
When the IRS finds that there's a debt due, the IRS squeezes your expenses down to an expected number. If this honorable court doesn't lock you up for 7 years, would you be willing to downsize your living from a 2025 Camry to a 2015 Camry or 2005 Camry?
Yes. Yes.
Would you be willing to squeeze your living expenses down below $8,000 a month to as low as you can go?
I'm at a point now, I don't really spend my money on me. Every time I make money, I put money away towards restitution. I give my mom money because she's knee deep in loans, like I told you. And I send money to my grandma from my uncle because he took out loans to help me too. So if it's outside of my children's necessities, I don't really spend money. I don't go out anymore. I don't vacation.
You indicated you're in school. When did you start school?
Earlier this year,
And you're going to which school?
Chamberlain University.
And what are you studying?
I'm in school for my Bachelor of Science in Nursing.
Is Chamberlain online or in person?
Both.
Where is the physical campus?
Perimeter. I go to the perimeter location.
How many hours are you carrying right now in the summertime, credits?
6.
This past spring, when I was hired, how many hours were you carrying?
4.
So you've got 10 hours under your belt right now. If you were not incarcerated this evening, when is the expected end date for this education?
May 2029.
And at that time, what degree would you have?
My Bachelor of Science in Nursing.
What would that allow you to do?
My specialty, I either want to be a pediatric nurse or a ICU nurse.
Have you looked into, can you tell us what the anticipated income for such employment would be starting out?
Yes.
What is it?
If I go in and I go in as a ICU nurse with my BSN, I'd have my RN, my BSN, and I'd be expected to make anywhere from $150,000 to $180,000 a year.
In the event you're not incarcerated throughout the next 7 years, in the event you can't gamble your way to full restitution along with your settlement of, how much is it?
350,000.
And what month of 29 do you expect to receive that?
It's my birthday, so February 22nd, 2029.
And taxes are not taken out of that. That's 350 up front. Is that correct?
Correct.
And you're committing right now under oath that money towards this restitution fund. Is that correct?
Yes, sir.
Plus the money you have in hand right now, right?
Yes, sir.
So with bad math, that puts us 400 of 600 on the way there, right?
Yes, sir.
If this honorable court, as the IRS would do, an offering compromise, squeeze your living expenses down to what folks can live on but don't want to live on after taxes, have you given thought to how quickly you can pay off that 200 on your anticipated salary?
Yes.
You have? What's the answer?
Well, I came up with the plan. My plan was I wanted to pay $20,000 a month. That's what I feel like I could pay and still live and provide for my children.
This is before graduating?
Yes, this is now.
And this is from gambling online,
Correct.
which is your position is you're anticipating you're going to make 20 a month going forward because that's what you've made on average the past 2 months?
Yes, well, I made a little bit more than 20, but of course I had my living expenses. I had to pay attorney fees. I had to pay my lump sum for school and all of that stuff. But yes, sir.
You've heard, besides the actual dollars, and then you've got to think about the impact of those investment dollars. If they were real investment dollars, they would be expected to grow 6, 7, 8%, right?
Yes, sir.
And you'd agree with me that all of these victims are not folks that have discretionary income to invest with anyone, much less with someone that doesn't know what they're doing, right?
Yes, sir.
So it's a particularly acute, painful experience for someone to give you their extra X dollars, be it 5 or 125, that they do not have to invest. You'd agree with me that that is horrific.
Yes, sir.
And you would agree with me that to profiteer off your own individual loss and the connection to these folks is as offensive conduct as we've heard in court. You'd agree with me with that?
Yes, sir.
You would agree with me that the pain that these folks and others would articulate, which has been well expressed, despite your ability to pay this money back, is something you can never make right.
Yes, sir.
You spent a month in jail for this so far.
Yes, sir.
As we recognize in courtrooms, when a defendant accepts responsibility and is punished for his or her crimes, they take their whole family with them, right?
Yes, sir.
And those babies in the hallway that you're caring for, you'd agree with me that despite your ability to overcome the things that have happened to you to this point, that you are taking them down with you.
Yes, sir.
Do the three men that fathered those children help in any capacity? Parenting, counseling, holding, talking to?
You already covered this. They're out.
Kayla, recognizing that your own trauma, though it has shaped who you are and the decisions you made, would you agree with me it is not a shield, nor can it be used as a sword
Yes, sir.
as an adult, right?
Yes, sir.
You agree with me that it's not what happens to us in life, it's how we respond to that that matters, right?
Yes, sir.
Can you look the court, Mr. Root and myself in the eye and tell us, regardless of what this honorable court's decision is, in terms of your future and your freedom, can you tell us you're not going to take your own life, that you're going to persevere, that you're going to overcome for those kids in the hallway? Can you tell us that?
Yes, sir.
That doesn't sound that you've said it with much confidence. Why not?
Those kids, they the only reason I keep going. Like I said, my first suicide attempt, my first hospitalization at a mental institute was at age 13. That's the only reason I keep going. When I was incarcerated in December, I didn't talk to my kids the first 2 weeks while I was in there. I told my mom I couldn't do it, and she told me I had to. And I talked to my 8-year-old on the phone in Christmas. It was Christmas, and she said she didn't want them for Christmas. She just wanted me to come home. And I've never felt like a worse parent. My children, they were suffering. She's traumatized by my actions. She's never gonna forget that I wasn't home for Christmas. There's nothing I can buy her. There's nothing I can say that'll make her forget that I was in jail for Christmas. And it's my fault. Without them, I don't have nothing. That's my life. I don't have a social life. I don't go out. I don't date. I'm with my kids 24/7. That's my life.
Hold on one second. You just stop. It just turned 5 o'clock, and we originally set this up only to run through 5. And so I think a few cameras have just turned off. The important one is still going because the podium is on, which means Ms. Rivers, the court reporter, can hear us. So just give me a second. Ms. Rivers, are you able to hear what's going on?
Yes, I'm still here.
Great. All right. Let me add back a couple of the cameras and we will make sure things are okay. We've extended it through 6 now. Not that we're going to be here till 6, but that gives us a cushion to talk a little bit more before things shut down. So let me just figure out how to do this. We're back on. I can't get that camera to work, but that doesn't mean we should stop going. The microphone works, which is the important part. Okay.
I'm almost done, Your Honor. Ms. Brown, is there anything that you would like to say directly to our victims?
So you can talk to me. You can talk to Mr. Ford. Your message can be for the victims to hear. But it wouldn't be appropriate for you to say, Ms. Thomas, Ms. Luke, those kinds of things. But if there is something that you think is important for them to hear, relay it to Mr. Ford, relay it to me. I promise you they're listening.
First off, I just want to apologize. Apologize to everybody that was affected by my actions. My actions, they cut deeper than the financial aspect. Relationships were lost. My mom and her sister, they no longer speak. My mom and her childhood best friend no longer speak. My uncle and his friend,
Your mother's sister is one of the victims?
a cousin of one of the victims.
Okay.
My uncle and one of his best friends no longer speak. I apologize for my actions. I want them to know that I'm not that same 19-year-old naive girl that I was at the time of these events. I heard somebody say that I wasn't remorseful. I'm very remorseful. I can't reach out to each victim individually and apologize because of course it would violate my bond, but if I could, I would. I think about this situation every day. It's not a day that goes past, it's not an hour that goes past that I don't think about this situation. I pray for every single victim every night. I pray that they forgive me. And I just wish to rectify the situation as best as I can. I know that the money won't bring back the time that's lapsed. It won't rebuild the relationships that were lost, but I'm hoping that that's a start. I'm hoping that the financial aspect of it heals some type of pain that I've caused. I understand their pain. I may not understand it to the same extent, but I want them to know that this case has had an effect on me and my family as well. Even though I'm not the victim in it, my family has been affected tremendously by my actions. I've been affected tremendously, my kids, and I just want them to know that I truly apologize and that I'm gonna make the situation right. I know that may not sound right in court terms, but I just want to make the situation right. I want to pay the people, their money back, and I want to rectify the situation.
Okay.
Ms. Brown, and are you representing to this court under oath that if you're sent to prison, your children are going to foster care?
Very likely, yes.
Very likely means what precisely? Why would they not go to foster care?
It's not a why would they not? My mom, like I told you, my mom cannot provide for my 3 kids. That's a fact. My grandma, she had to come up here and sit in the hallway with my 3 kids because my grandma cannot watch them by herself. My grandma is almost 75 years old. Even when she comes over and she, visits my kids or whatever, she might hold my son for a couple of minutes and she'll say, Kayla, get this baby. He hurt my back or he's hurt my arm or whatever. Their dad's no position to take them on. Cason's dad, he doesn't even have any type of relationship with him. I included a child abandonment warrant in my letter to you that was filed last year. I'm literally all my children have.
Mr. Brown, Your Honor, the state may have questions for you. Thank you, Your Honor.
Mr. Wooten, I know that Mr. Ford's presentation was different from what we sometimes see, but I took it in many ways as the way he was making his points through the questions he asked, some of which the answer was obvious yes or no, but Mr. Ford was making important points on behalf of his client. So I don't want to preclude you from the opportunity to ask Ms. Brown questions, but in a normal plea, I wouldn't let you ask the defendant anything. And so if there's something that you think really, really needs to be cleared up, I'll let you do that. But I appreciate this format, and it allowed Mr. Ford to do some of the things he felt he needed to do. But I don't want to open this up to, well, you said this, and what about the EIN number that you were asking this poor woman for? So use your discretion. But the most atypical thing about this would be if you ended up asking Ms. Brown a whole lot of questions. She's admitted her guilt, whether she's taking a whole lot of responsibility for it or not, I'll decide, the victims will decide. But that's sort of where we are.
And Judge, I have a lot of questions, but I will save them for another proceeding in case we go to trial on the other defendants and Ms. Brown is a witness.
Okay.
We'll save it for that time.
Okay. Anything you want to ask her about?
Nothing, Judge.
Did you end up getting a copy of the binder that Mr. Ford delivered to me?
Yes.
Okay. All right. Ms. Brown, I have a question for you. You didn't include a whole lot of the bank statements. You gave me the kind of last page of your March, and it's just your Wells Fargo bank statement. It sounds like you also have everyday checking. So this may have been like the savings or something, but you highlighted all the deposits you've made. Of course, the withdrawals were pretty close to the deposits. And I just want to make sure I am level setting the right way here, because you've talked about how you have tried to simplify your lifestyle because you've got this eye towards building up restitution, et cetera. You've also told me that you lived large in the past, and I couldn't help but notice that one of the final entries in your March 26 bank statement, one of the withdrawals, there were some basic things, is transfer to Apple Cash and this and that, Prize Picks. It makes sense that you have things going to Prize Picks. But there was also a purchase for Louis Vuitton for $1,300. And that seems kind of jarring, lined up against all the other things. I want to give you a chance to try to explain it while I'm thinking through your claim that you're living simply and really all your money is taking care of your kids or putting together what I'm going to call the restitution nest egg. So walk me through that one.
Okay, so you said the thing about the withdrawals. Every day, you can ask my mom. I go to the bank and I take out the cash and I put it away. It's locked away somewhere very securely. I do that so I won't have access to the funds to spend.
You're protecting the money from you.
Exactly.
Okay.
The purchase at Louis Vuitton, that was a Mother's Day gift for my mom. My mom advised me not to do it, but I told her I felt like I had put so much stress on her. Because my mom, like I said, my mom would literally come home from work when I was living with her, just crying. And when I asked her why, she said, I'm okay. And I know it's because of this.
Sure.
And I just felt like she deserved some type of appreciation. She told me multiple times not to. And I said, Ma, I'll make the $1,300 back. I got some slips in tonight, and I felt like my mom deserved it.
Okay. One other question. You started out as a successful investor, which has some parallels to betting, and then it didn't go so well. Tell me why you think that any of us who are interested in you being financially successful in a way that helps make the victims whole, financially whole. And I understand fully that there's not going to be a complete healing for many, many of the people that you've hurt. Why is online sports betting any more reliable than stock picking, other than the fact that for the first few months you've done well? Because, of course, you've read this, I know, past performance is never a guarantee of future results.
Sports betting, that's my lane. I grew up playing basketball. I grew up bonding with my dad over football. Sports is my lane. I know the back end of it. It's not just me going on the site, putting in random numbers. I study. I'm up at 2 a.m. every morning, studying stats, studying who's injured, studying who's this, studying who's that. According to my Prize Pick account, I have an 88% accuracy rate. That's almost unheard of, especially from a female. And another reason why is because If I don't make money, those three out there won't eat. And that's not an option for me. So, yeah, that's why,
Okay. Thank you.
sir.
Mr. Campbell, can you hear me? Yeah, you can step down. Thank you.
Yes, I can, Judge.
I appreciate you being on for this entire proceeding. I would like to talk to your client real briefly, not about the facts of the case or her involvement in the case, but I don't want to do that without you telling me that that's okay.
That's fine, Judge.
Okay. All right. We're going to take a quick recess, partly because the court reporter has been typing nonstop for 2+ hours, but also because I would like to speak with Ms. Jones real briefly. After I speak with Ms. Jones, I would like to speak to counsel, meaning Mr. Ford and Mr. Wooten real briefly. We'll just go into the jury room. That's easiest. Ms. Jones, if you could join me in the jury room for a quick second. You're not in any trouble. I just need to ask you a couple questions that I'd like to just you and me talk about it, okay? All right. I am going to mute things out here so you can talk and it's not going to go to the many interested people who are following this. And I'll unmute when we're back on the record. So click and is there something you can click that unmutes?
Does that work?
You did it.
Good.
See? Don't undersell yourself. Exactly. He's going to tweet about it now. Jen Q.
I'm done with Twitter.
Yeah. Good choice.
Just leave it.
All right. Ms. Rivers, can you hear us now?
Yes, I can.
Excellent. Saved by technology. We're going to get back on the record in this matter. We took a quick break to rest the court reporter and for me to gather a little bit more information. Mr. Campbell, thank you for letting me speak with your client. I am ready to move forward. And I want to get all the paperwork together. So Ms. Brown, I think we can go forward now. First, I find that there is a factual basis for your plea based on the information that Mr. Wooten provided in his factual summary. I also find that your plea is knowing and voluntary. Knowing means you've understood the things we talked about. Do you have any questions about any of the things, not that the victims had to say, but when Mr. Wooten was talking to you about your rights and the consequences of a plea? It was a while ago, but it was this afternoon. Any questions about any of that?
No, sir.
Okay. I also find that your plea is voluntary. That means that no one is forcing you to enter the plea, but you've decided after consulting with your lawyer and family that the right way forward for you is to enter a guilty plea. Is that correct?
Yes, sir.
Okay, then I'm going to accept your guilty plea. Mr. Wooten, can someone in my office sign the indictment on your behalf?
Yes, Judge.
Mr. Ford, can we sign for you?
Yes, sir.
And Ms. Brown, can someone in my office electronically sign your name to the indictment indicating your guilty plea?
Yes, sir.
All right, we'll do that. So Ms. Brown, I think one of the most informative aspects, I hope it was for you today, was to hear again, I know you've had to hear it before at hearings that we've had, although we had a few additional victims here, was for you to hear and feel, and I hope understand the impact that the things you did, the decisions you made, the facades you created, and the sales pitches you made, the impact that they had on these people. In the grand scheme of things, these dollar amounts are small. If we go into federal court, fraud trials are for hundreds of millions of dollars. But life happens on the granular level. And so I was able to hear about a security clearance lost, about a child who wasn't as well funded because of therapy, not that you're taking now, but that your victims are having to go through because of the hardship that their financial loss has brought them. And also, and to me, this was even more fundamental because money is money in the end if you've got people around you. It was this loss of trust and faith that people have, not just in you, but in general, that we have people who now trust each other less. They suffer from anxiety. There isn't anyone in this mix here who had this money extra just sitting around saying, great, I got an extra 100 grand. Maybe this is the next Bitcoin and I'll do real well. This was cutting into the financial bone of all these households. And this restitution that we're talking about, it repays the amount that they put in. It doesn't repay them the opportunity cost that was lost. Maybe someone did invest in NVIDIA back in the beginning instead of doing what you did. And they would now be gazillionaires if they had invested in NVIDIA. So they've lost that opportunity. They may have found solidarity amongst themselves, but it certainly is something that has affected their lives. I preside over murder sentencings where the family members of the deceased are less upset than some of the folks we've been dealing with here. And that's not me saying their anger is out of proportion because their loss is different. I think there's a certain sense of finality that comes when you've lost someone to a murder. You know they're not coming back. And the only healthy way forward is to say, I have to let go. And they may not forgive the murderer, but the person's not coming back. Here, because it's money and they may get money back, I think what I heard from a number of these people is they don't want you to think for a moment that putting that money back in their pocket makes them whole, because it won't. They were deceived. There's an embarrassment behind. I had a 19-year-old convince me, and I gave her $50,000, and they should have known better. I just met her through Instagram, and they should have known better. But you convinced them that you were trustworthy, and you weren't, and they suffered a great deal because of that. I appreciate some of the anger, and that some of these victims have said, I don't care if I get a penny back, you need to be buried under the jail. So in essence, what I heard. And I understand that perspective. That's not how this is playing out. I think there is a middle ground. I think there need to be consequences for you as a result of this, and the consequences aren't you become a real good Prize Picks person and you pay people back. I didn't hear anyone say, if you just give me my money back, it's all okay. Because of the suffering that you brought them, there needs to be a deterrent factor to this and also a punitive factor. That's part of what sentencing is about. For me, it's not in a vengeance sense. That's the bury you under the jail and give you a 150-year sentence. That would be disproportionate. The reality is, in our community, of which we are all a part, we don't sentence people to 150 years for a fraud crime. That's what this is. And that's not minimizing the harm to other people. But 150 years is reserved for rapists, child molesters, murderers. You are not any one of those things. You don't fall in that category. You're never going to fall in that category. But you are a very, very effective scamster. You deceived each of these people. And hearing in particular the scenario, I believe it was with the Lukes, where you formed this bond of, oh, I lost my father too, which you did. You didn't make that up. But that preyed on a vulnerability, whether you perceived it or not, that is pretty scary when it comes to fraudsters. It's one thing to say, look at my fast lifestyle. Don't you want to be like that, even though you didn't have a fast lifestyle? And it's another to figure out, hey, if I pick at this right here, there's going to be a certain solidarity, and someone's going to trust me because of that connection. And that's a little scary. I got to tell you that. But it's not 150 years under the jail kind of thing. And that may frustrate some of the folks on the call, but I have to look at this across all the cases that I get. And the people who go to prison for 150 years have done something horrific to a little kid. They've killed someone. They're serial rapists, something like that. But as I said, this is not a crime without consequences for the many people. And that's the difference I want to draw here, because the examples I've given is someone shoots someone is one victim. And the family of the person who was shot is victimized. They lose someone, or their someone now is missing a leg or is incapacitated. Here, I didn't get to hear from all the victims. There are that many. It's a long list, and I appreciate the observation coming from one of the early speakers that there are probably a few others that we never learned about. My guess is the dollar amount wasn't huge because, as Mr. Wooten pointed out, there were a whole lot of law enforcement agencies sniffing around in this case, and they would have uncovered if there was someone who lost the amount that Ms. Burbridge lost, or some of the others did, Ms. Thomas. But it still is a more egregious crime because of its repetitive nature, meaning multiple victims, and the way in which you went back to each of your victims saying, you got to give me more, you got to give me more. And I appreciate you explaining that you were feeling a certain despair because you were trying to pay someone back. I meant to ask, Mr. Wooten, several of the victims were incredulous at the claim that some of the money that went in was used to pay some people back. And I'm curious if the deep dive that your team took looking at finances, if you could even tell by looking, if Mr. Ford described it as a Ponzi scheme. And with Ponzi schemes, some money is going out. And the lucky people who got in early, They may make their 10% return, but anyone who gets in halfway or later, they were never going to see anything. Did you see, did anyone get anything back?
I don't believe anyone ever got anything back.
Okay. Well, and change how I'm going to process this, but it's helpful to understand that. So, Ms. Brown, regardless of how you were feeling in terms of needing to get more, whether it was to, in your mind, prepare to pay people back, or it was to support the lifestyle that you needed to display to convince people to continue to go along with things, it was a long-term deceit. It wasn't a one-time thing. Hey, give me $50 and I'll give you 60 tomorrow. It was orders of magnitude higher financially and broader in terms of the scope of the number of people that you impacted. Ms. Brown, you are going to have a sentence that involves you going into custody, but I'm giving you a turn-in date. I've had important discussions with people who know you well and people who care about you, your lawyer, your family, et cetera. And I believe that a turn-in date is appropriate, and more importantly, it's safe, meaning between today and the time you turn yourself in, you're going to take care of yourself in a way that keeps you going so that you are there for your kids and your family when you're done with the time that you're in custody. You have a tomorrow. Your sentence isn't going to be, we'll see you when you're 90. I'm going to tell you the sentence in a minute, but I want you to already start processing this, because in the end, better than your lawyer or the people who are close to you and your family, you know best whether a turn-in date is a wise idea or not. Because you could go into custody today. We can do that if that's the safest thing. Because I know you've planned for the possibility of custody. Mr. Ford is a magician, but he's not an idiot. And so he would never have promised you there's no way you're going to go to jail. You are. I think it's appropriate to allow you to get things organized a little bit and even say, here's some money that's going to the registry of the court so that restitution begins. It certainly doesn't finish, but it begins. And so that can happen in an orderly way. But that's not what's going to happen if you think that that's not safe for you.
You understand what he's saying?
Yes, sir.
And I'm going to let you think about it a little bit. I'm going to lay out the full sentence, and then you and Mr. Ford and anyone else who's here for you and with you can talk about it. And you can let me know, turn-in date or not. So here's where we're going with this. Ms. Brown, I'm sentencing you overall to a term of 15 years to serve 5 years with a balance on probation. You get credit for the time that you've been in. And as I'm sure Mr. Ford has told you, this is very much a parolable offense. I have no control over parole, but the Board of Pardons and Paroles looks at your criminal history, the severity of your offense, particularly in were you out shooting people and gang member and that kind of thing. So I suspect, but I don't guarantee, that you would score well on the parole front, which means you'd be out sooner to begin earning to deal with the restitution. But just as important, you're a person too, to reconnect with your family, your kids in particular. But I don't think that a purely probationary sentence reflects the seriousness of the offense, or as we've all heard today and on several instances before, the impact, the victim impact here. It's been profound. And so I do think custody is appropriate. I do think the additional probation, because I've added a few years probation because I've subtracted a couple years in custody. Given parole, I don't know that those numbers really change a whole lot, but that's more time for you to pay the restitution back. I intend on having as part of my sentence that the payment that you get in 2029 is actually forfeited to the state, not to reimburse the district attorney's office, but to go into restitution. I don't know how to word that. So I'm gonna work with your lawyer and the prosecutor so that the sentence makes very plain that if restitution has not been paid, by the time that lump sum, that final lump sum comes, that all goes to restitution. It won't be a, hey, I'm doing this to pay off restitution. It's actually structured. Because it's conceivable you're still in custody then anyway, and I don't want to delay that going into the pool that will make restitution payments out to the victims. I'm going to talk with the lawyers about how we structure the cash bonds. I'm inclined to direct the cash bonds to your mother rather than to the restitution pool. Not because I want to shortchange the folks, but the $30,000, I think yours is 20, that represents is a drop in the bucket for restitution, but it is pretty meaningful in terms of added responsibilities that your mother may have once you go into custody. But I'll build that into the bond, the final disposition as well. I need to talk with the lawyers how to structure that. You will continue to receive, I think it's monthly payments, but I'm going to need Mr. Ford to get from you all the specifics about how those monthly payments come in. And I'm going to work up what it's going to say in the final disposition as to how those are split between going to your mother and going into the restitution pool. Some of it will go to your mother because she's taking on additional responsibilities while you're in custody, and some of it will go into the restitution pool. The other conditions of the final disposition you have, I'm fine with, but I'm customizing them a little bit because of how this is playing out. And as for the specific sentence, because I need to pronounce it, it is on count 1, 15 years to serve 5, and then it is 5 years to serve on all the remaining counts. So it doesn't look all that different from what the state put together. It's just a little more probation, and it's two fewer years in custody. With parole, I think that all comes out in the wash anyway. But in my 14 plus years on the bench, this is by far the most severe sentence I've imposed for someone with a criminal history that you have, for a set of financial crimes. This is also the most expansive set of financial crimes I've come across. But I do want to put that in perspective for the people who are listening and maybe thinking that's an inadequate sentence. And they're entitled to that view, and that may be how they process all this. But they should also keep in mind that for Fulton County, this jurisdiction, this office, and this judge, this is a particularly weighty sentence being handed out for a financial crime. I'm not saying merely a financial crime, because there's nothing mere about this. It's not a victimless crime. It's one that is rife with victims and impact on the victims. But for me, it strikes the appropriate balance between there being significant punitive and deterrent consequences for Ms. Brown, coupled with the reality that repayment is part of the process. And that means you need to get out and be productive. You've got a lot of horsepower in your head. If you can apply it in ways that don't get you in trouble and deceive others, you're going to be able to take care of the restitution and do the things that you want to do. I am not sentencing you as a first offender. I know that Mr. Ford asked for that. I'm mindful of that. And while you qualify for it in one respect, any way I unpackage what this case is about, it is full of multiple offenses, multiple victims, people being re-victimized. And I think it's important that this be something that you carry with you so that there is less of a risk that you slide back into a situation like this again. Okay? If there's anything you think I didn't cover, Mr. Wooten, in terms of the final disposition, any of the special conditions of probation, I intend to incorporate the ones that are in your sentencing notice. Mr. Ford will have a copy of that, and you're going to get a copy to Ms. Nelson and or Ms. Rivers. So we'll work on the text from that. But that's the plan.
Only thing, Judge, that I think we should, just to make the record extra tight, is if we could just do a waiver of the restitution hearing on the record.
I think that's a good idea.
To be safe.
Okay. Based on the amounts that are in the sentencing notice, do you waive a restitution hearing? It sounds like some of them are a little lower than a few of the victims thought. Others, the victim said that lines up.
Let me explain what we're discussing. So
Okay.
I know when you came to me, you thought that it was 300 that you have. And there was a hearing, lawful front hearing, in which it was enumerated. And we've discussed that same list, the victims and their amounts of restitution. And we can see that list, but we're taking the face value. Your Honor has the same, state has the same, the math adds up to the number the state has articulated, which is 600 plus, right?
Right.
So you have the right to insist upon a restitution hearing, which would require the government proving by a preponderance of evidence as to what the amount of loss is. However, you also can agree that the amount is what it is. And the state has gotten to that point by virtue of the electronic record of money coming into your account from all these people. So my suspicions are, you weren't paid in bags of cash. My suspicions are it's irrefutable. So it would make no sense to have restitution in respect. We stipulate.
Okay, you stipulate you waive the hearing. Okay, it's waived. Ms. Brown, the last thing I need to cover with you is a turn-in date. And it is my proposal that you report to this courtroom at 9 a.m. on June 15th. That's a Monday. So you need to be here at 9 a.m. What you need to, is that a,
Can I ask one question?
yes,
My daughter's birthday is June 25th. Can I get my daughter's birthday with her?
you can have her birthday early. June 15th is when you need to be here. And I need you to understand this. This is probably the most important thing I'm going to impress upon you before we wrap up. If you are not here at 9 a.m. on June 15th, and do not bring your children, 9 a.m. on June 15th, I will sign a different sentence. And that sentence is going to be 15 years to serve. Straight time. No probation, 15 years to serve. This window is an opportunity to get things settled, to line up what you can in terms of restitution. We're going to work on a few things I mentioned with the lawyers. But it also reflects the reality that there are a lot of moving parts, and you're going to be going away from your children for a while, and that is significant. And so I want to give you a moment to line that up. So it would be June 15th, 9 a.m., this courtroom. I'm going to be here. If you're running late, you call Mr. Ford so he can call me and say, don't worry, she's on her way. She's going to go on FaceTime. You can see she's coming. But if it's radio silence, I have a hearing at 9:30. If I come out here at 9:30 for the hearing and my deputy said, no, we didn't see Ms. Brown, I'll reach out to my staff and say, bring me the 15-year to serve sentence, and I'll sign that one. I'll be sad about it, but I won't hesitate to do it. Is that clear?
Yes, sir.
Any questions about it?
No, sir.
All right. Mr. Ford, anything else?
Would you like counsel press on the 15th at 9 a.m.?
That's up to you. If Ms. Brown is on her way, that's great. It's real simple. Deputy Gordon will probably be here. He'll just say, hey, are you Ms. Brown? And we do it. So if Ms. Brown would like you here, you should be here. I've done it both ways.
You don't need me.
I don't. I need Ms. Brown, 9 a.m. on June 15th. Okay? That's it.
Thank you all. Great.
Thank you, Ms. Rivers.